हेलो चेक हेलो यस हेलो चेक हेलो हेलो चेक हेलो
Lords, 801 is coming out 18th of May, Lords, not to be deleted.
Yes. Next,
Grateful, Lords.
18th May,
Yes, sir. 802, Lords.
18th May. August.
My lord, this is just within 2 minutes, can be disposed, my lord. And last time, 29th and 6th, it could not reach it. Any miscellaneous day, Friday or Monday, my lord.
Not before the parliament.
My lord, because that trial is pending, my lord, because there is no stay, stay has been not granted to the High Court order.
August. 15th May. My lord.
It's in 804. I'm
August,
requesting
interim
for.
application.
Minutes 805.
805 interim application in August.
Minutes I am in custody for 10 years. And minutes leave has been granted. Early date I request minutes this month
August,
if
not
possible.
before August, sir.
Minute, can it be July I request?
July, only 15 days we have.
Minutes.
In August, it will appear.
It's in 804. I'm requesting for listing. I have filed my additional documents. It was directed to be listed after 1 week once the additional documents are filed. I filed it.
15th May is the date being shown. 15th May.
Obliged minutes.
Your Lordships, may I mention the Indian Railways matter in which your Lordships had delivered the judgment on 8th of May last week. Your Lordships, I was appearing on behalf of respondent number 13, Gridco. I was being led by my senior Mr. Sanjay Sen and briefing counsel Mr. Odijit Moitro. Your Lordships, the submissions of respondent number 13 and the appearances are not reflecting.
So what do you mean to say?
Your Lordships, I'm just requesting if the appearances and submissions may be recorded,
So
Your
now you
Lordships.
rewrite the judgment.
No, Your Lordships, it's in our favor. Only Mr. Sen had advanced his arguments. It was recorded by Your Lordships also.
Write all submissions.
No, Your Lordships, it's just a request, Your
Feel
Lordships.
be happy.
Your Lordships, at
You'll
least
record your appearance.
This kind of request I'm hearing for the first time.
Your Lordships, you filed the note also. It was not. Okay, Your Lordships.
Yes, I'll clarify. I didn't find any substance in it.
Your Lordships, the appearances may
sorry.
be,
Yes,
appearances may
that's
be
a genuine
recorded, Your
request.
Lordships. Grateful,
Appearance
Your
will be
Lordships. Grateful, Your Lordships.
Lords.
appearance क्यों नहीं दिखा?
Your Lordships, will hand over the appearances again.
My lords, may I kindly mention an after notice matter? My lords, this was mentioned in a listed mentioning. Yes, my lords. My lord, I'm saying this is an after notice matter because, my lords, it was stayed in May of 25. We had moved a listed mentioning last month, my lords. But the person who was supposed to mention, there was a medical emergency in their house. My lords, that's why now the matter has been directly listed in July. There is some urgency, my lords, may be listed this side of the vacation on any day convenient, my lords.
Sir.
My lords, there is a another proceeding pending between the parties, my lords, where they're
The list.
relying on the stay.
Follow
because
the
they are-
list.
May I please, my lord?
I'm great.
My lord, on the last date of hearing,
My lord, I'm appearing for the
Lordship has
number 2.
directed me to find out whether the learned single judge who had decided the matter had the roster or not, my lord.
Yes.
My lord, we have placed on record the, my lord, roster of the High Court, my lord.
Had
The-
the determination.
No, yes, my lord.
Why do you say so?
Lord,
Please
no.
come to page 3 of your counter, of the counter filed by the Uttar Pradesh government.
Lord, I don't have the counter, my lords.
You don't have the counter?
No, my lords.
We have already supplied advance.
What is
copy,
this?
that's why only.
It has been placed on record.
We have,
We must have emailed to the AOR.
You must have been served, otherwise how could it be part of the record?
Lords,
Don't forget about that. Because it can be heard by either by Honorable Saurav Lavania J or by Honorable Rajiv Singh J.
no, my lords, I have placed on record the constitutional bench, my lord. My lord, in fact, my lord, may kindly have my additional
Can
document.
you
my lord.
please give your counter?
yes.
And please come to, this is not paginated. This is not paginated. You come to annexure R1.
Yes, my lord.
R1, page 3. R1, page 3.
Yes, my lord.
Right. Now see serial number 13, Honorable Lavania J.
Yes, my lord.
He has determination in respect of all major bail applications. Right? Now come to Honorable Rajiv Singh J.
Yes, my lord.
Number 3, all criminal matters not provided elsewhere. So this is not a bail application under 482.
Yes, my lord. Lord,
This is a suspension of sentence matter.
Yes, my lord.
And you will not find in this list
No, my lord. it
that
is there.
anybody else has been given suspension of sentence.
My lord, the,
So it comes within number 3.
my lord, the criminal appeals, my lord. My
No,
lord,
it's not
kindly have-
criminal appeal is separate. This is an application under 389.
my lord,
There is some ambiguity here. If there is an ambiguity, we will rule in favor of the learned judge who has taken up the matter. Argue on merits.
please, my lord.
Madam, I'm the aspirant respond number 2. I need to file counter. My
Lord, it's a cold-blooded murder, my lord, my
I-
lord. 5 anti.
You are entering appearance today.
No, my lord.
He appeared, my lords, on the
But I could not file, my lord.
No, but office report says that nobody has entered appearance.
Lord, he was on caveat.
He was on
I was on
caveat.
caveat, my
He
File your counter.
lord.
2 weeks for counter, 1 week for rejoinder in the week commencing 20th July. We have heard learned counsel for the parties on the question as to whether the learned judge who passed the order impugned had the determination to hear the application for suspension of sentence under section 389 CRPC. Having looked into the documents, we are satisfied that the learned judge did have the determination. The objection of the petitioner to this effect stands overruled. Uske baad counter.
May I please, my lords? My lords, I am in custody, my lords, for 4 years and 4.5 months now. And my lords, all the 4 co-accused.
Yes, matter.
Yes, my lords. All 4 accused have been granted bail, my lords. And my lords, out of total 25, only 6 witnesses have been examined.
You were traveling in the truck
Yes, my lords. I was the cleaner, my
and you made an abortive attempt to flee.
No, my lords.
Thereafter,
I was apprehended at
thereafter you
Passover.
were apprehended there,
Yes, my lords.
right? 6 have been examined out of 25.
Yes, my lords. And my lords, 4.5 years, my lords, I have undergone.
You are both the other side.
Please, my lords, I'm for this.
Have the co-accused been granted bail?
4 of them, my lords.
I'll have to get instructions or that this is in advance service, ma'am.
My lords, we have annexed the orders also, page 55, page 57, and page 60. 4 co-accused, all of them have been released on bail.
The driver has been granted bail?
No, my lords, driver expired during the trial.
So who are the 4 who have been
My lords,
granted?
according to the police, they were the suppliers of. I was the cleaner. I was, my lords, only 20 years old. My lords, I was only 20 years old.
Very well, you file your counter. Notice counter.
Quantity is too much.
My lords, may I have it this side of the.
No.
Obliged, lords.
The respondent number 2 participate actively in forging the power of attorney, and due to that power of attorney, my lord, kindly consider, my lord, even my lord in revenue
Grant of bail, we are very.
even in revenue entries, my lord, my letter has been forged, my lord.
Court has granted bail, we will take away the liberty. In a 420, 467 case.
My lord, this
We
observation
could
made by-
understand if it's a
Yes, my lord.
murder case. Not in a 420, 467 magistrate travel.
Whatever the observation should not come in my way in the trial, my lord.
Of course, it is for the purpose of disposal of the bail application.
May be observed, my lord.
No, nothing more.
I am deeply.
Yes.
Milord, the respondents had not complied their own letter, Milord. Kindly see on page number 63, Milord. In 1986, the petitioner should be a deputy commissioner, Milord. Kindly page number 63, Milord. The junior of the petitioner become the deputy commandant in 20th of August 1986, Milord.
The single bench holds that in a contempt petition, you are canvassing the issue of your compulsory retirement.
Yes, Milord.
Why?
Milord, in
Huh?
1980.
Why? That has certain finality with the order of the Supreme
Yes,
Court.
Milord, we agree, Milord, but there was the order of the.
Which order has not been complied with? Which order of the court? Don't show any departmental order.
Yes, Milord.
Show us that this is the contempt.
Single bench of the single
Which
bench
page?
of the Kolkata High Court on page
Which
number
page?
117, concern portion.
117.
117.
117.
Starts
Come to 117.
115, Milord.
The single judge has been so sympathetic to your cause. Para 15 has directed disbursement of all amounts, right? Calculated from September 96 to February 2019.
Kindly see the second para,
And
second para.
your-
Kindly see the second para, Milord.
There is only one error committed by the division bench. Division bench says that intra-court appeal is not maintainable. That is erroneous finding.
My lord,
But the appeal has not been dismissed only on that ground.
my lord, for a moment, see second para on page number 117, my lord.
Sir, what's your age, sir?
It means plan's age.
85.
He got everything. What is this?
Although we are not,
As per your own letter, he should be the deputy commissioner
although
of
we do not agree with
1986.
the
my lord.
finding of the division bench of the High Court that the intra-court appeal against the order passed by the land single judge disposing of the contempt petition was not maintainable is incorrect, having regard to the decision of this court in Midnapur Cooperative Fluenso Bank versus Chunilal Nando. The division bench is right in observing that the order of the single judge dated 13 September 2019 did not merit any interference having regard to the indulgence shown by the land single judge. No reason to interfere, dismissed.
My lords, this is statutory appeal under section 22 of the NGT Act. In this matter, my lords, my review application has been dismissed by the NGT after finding that they don't have the power. My lords, may I just show the proof?
This a platform I constructed so
Yes.
that people
My
don't
lords,
drown.
without any provision, without any permissions, my lords, in CRZ one
Platform
area.
is removed, there will be flooding.
My lords, that's
What is the size
only
of the platform, madam?
4.5 into 10, my lords.
What is-
I understand, my lords, but this is done in a CRZ one area, an
Please don't,
ecologically sensitive
convert
area.
these matters into ego issues, right?
My lords,
If
see,
something has been done,
my lords,
assuming without permission,
my lords.
but there is a finding given by two authorities that it is ultimately benefiting the public, why should the authority?
My lords, the finding is on the basis of a site inspection report not approved by GCDMA, my lords.
Dismissed.
My lords, may just see the site inspection report on the basis of
Next
which
matter, madam.
I'm grateful.
It's the Honorable High Court literally has said that so far as OBCs are concerned, there should not be any time limit for the.
No, why did you curtail the window?
Let's.
Why did you curtail the window? Is it possible? Is it possible today you say that you need to bring certificates between, say, 1st of April to 15th of May. Suddenly, in the midst, you say that, no, the window period is curtailed by 20 days.
No,
it will be within 15.
Not in the missed millets.
No,
In the
that is there.
the advertisement itself, millets having been issued.
There's a larger issue involved in this case. You want to crush the career of OBC people on a technical ground.
No, millets.
No, there's no finding
that they do not belong to us.
That don't belong to OBC category.
Let's kindly consider.
Where is that finding? There is no finding. You are only saying that your certificate was not obtained within the window provided.
Lordship, let's.
They are OBC candidates.
Let's out of 500 candidates who applied.
Maybe some were fortunate, but we also know how government officers proceed.
Let's. Would your lordships consider?
Unfortunately, these 42 people may be faced with officers who would not act without silver.
Would your lordships consider only one thing, let's. Ram Kumar Gijroya. Let the question.
Having regard to the peculiar facts and circumstances.
Question of law may be left open.
Having regard to
I was on caveat. My caveat expired. Just one submission. Though my lords are dismissing it. My lord, for 2020.
You are the candidate.
Yes, my lord.
You are the candidate.
No. My lord, I was a lawyer in the High Court also. I filed caveat.
Who are you representing?
For the petitioner, respondent, my lords.
So candidate.
Yes, candidate.
So if you are dismissing the matter, where is your right of audience?
No.
As a caveator?
No. I just wanted to make one fair submission.
No, please don't make it. Let's open.
Having regard to the peculiar facts and circumstances noted by the division bench of the High Court, we see no reason to interfere with the impugned judgment and the special petition stands dismissed.
But the question of law with regard to the cutoff, whether
Peculiar facts and circumstances, we have said.
My lord, I apologize.
Grateful.
Please don't open your mouth when the court is with you.
No.
You may be extremely fair, but we don't require your fairness now. Because it may so happen that what you think is fair could turn to your disadvantage. Right? We are very strange people. We can take views, we can change views very abruptly.
That's a fair
Especially
advice.
both of us, especially both of us.
That's a fair
In
advice.
number of cases when the cavator stated something, we have issued notice because he stated something contrary to the record and contrary to our thought process.
I'll not get him.
Right. Yes.
Grateful.
Thank you.
Yes, my lords.
What else is, what do you want, sir?
My
Speaking
lords,
order
sir-
has been passed.
No, my lords, it was not, it was
Sir,
directly.
sir,
Yes,
only error that we find in the order is, instead of the date 27th October 25, it should read 13 January 26.
right, my lords. This is one. And my
You
lords,
challenge that order of 13 July, January, we will clarify that.
my lords, because it was also directed to preserve the CCTV camera.
They
But
say that
what-
because of monkeys in the
Yes, my
areas,
lords.
we don't have that CCTV.
But this is a false statement by the.
No, you are mistaken.
Yes.
Come to my house. Hundreds, more than 100 monkeys, they are daily in my house.
But my lords,
No, I know the ground reality.
because
No.
I was just standing, he was a just 2 months lawyer and
That's a valid,
13
valid
January
defense.
26 order, you go and challenge.
that I will challenge, but my lords, he was
With the impunity.
tortured badly by the CIA staff and where he was standing, my lords.
We only clarify that the date of the speaking order is 13 January 2026 and not 27th October 2025
Then
as erroneously recorded. in the
liberty
order.
may be given to challenge that. Liberty may be given to challenge that. Right, I'm.
Learned judge has given you liberty, but liberty against order of 27th October 25,
Yes, my lords.
which does not exist.
Yes.
We have clarified that it is the order of 13 January, you can check.
But my lords, very badly, he was beaten 2 months lawyer, he was
case-
at that time, and the CIA staff is misbehaving in Gurugram, my lords, I personally know. They are misbehaving with everybody, just torturing and extorting money.
The order does not require it.
2 months lawyer at that time, his registration was there.
Well, next matter.
Please, my lord, I already tendered my resignation, my lords. My lords may have it after 2 weeks, my lord.
Why?
Due to change of government.
Tamil Nadu.
Tamil Nadu.
Oh. Adjourn. 2 weeks as paid police, Indira.
Much.
May it please you. Yes, I beg to appear for the petitioner. In
There's
a-
only one issue.
there is an
Problem is there. It's a
interfere,
2001 tender.
not 2001.
Yes, 2001. It is
Period was 2021 to 2027.
Your lordship said
Not
2000.
2000.
NIT was issued in 2001.
No,
When NIT was issued.
2021.
21.
There's no delay on my part.
No. So it's a 6 years old NIT.
Yes, ma'am. It was challenged in a writ petition, ma'am.
There's always a clause that the department reserves a right to cancel.
But the
tender.
department doesn't say that, Manoj. I can understand if the department says.
The contract period is from 2021 to 27.
No, Manoj. It says that your lease will run from the time that the lease is executed. So the 7-year lease will only, it's not been executed.
Well, it has not been executed, so time has not started running. That
Your
is
lordship.
But the court has kept in mind the revenue interest of the government.
Yes.
Discretion has not been exercised in your favor, DBA has upheld the order. Why should we interfere in a discretionary order?
So let me answer that. Two aspects. One is, my lords, there is nothing to show that there is revenue loss. I can understand, my lords,
Being on record means
with
2021,
respect,
whatever would be the rate.
no, with respect.
And if it is advertised now, 2026.
No, Manoj. Someone has to come to the conclusion that the price of sand has gone up. There is nothing to show that. Point number one. Point number two is, Manoj, the department has never said that please retender. That there is a revenue loss and there is a retender.
Invoke the
Now the
discretionary
third point.
jurisdiction.
The third point, Manoj.
Department may not say so,
No,
because we
third,
know how departments function, but it is after all the High Court, which is the guardian of the Constitution. If it
But
has
let-
taken a view that
let me-
interest of the state would be best served if there is a retender, you require very strong reasons to dislodge this.
So may I now, Manoj, state one reason why your lordship should dislodge the reason. Your lordships have repeatedly said that judicial review, my lords, in a tender matter is extremely limited. Only on the principle of Wednesbury arbitrary. The finding of the single judge or the finding of the division bench, there is no finding returned that there is Wednesbury arbitrariness. Your lordships have gone to the extent of saying in a tender matter, we will only interfere where the arbitrariness, my lords, borders on perversity. I ask myself this question from the division bench order or from the order of the single judge. Where is the finding returned that there is any arbitrariness? The High Court.
In tender matters,
Yes, my lord.
courts have to decide the list, keeping in mind public interest. Even if you make out a solid point on law, the court may refuse to do so.
It may.
Right?
It may, my lords.
India,
Now let me point.
India Maritime, these decisions are there from 2001 on.
Yes. Now let me point out, my lord.
Court may not have referred to those decisions.
Yes.
But the essence of the judgment is this, that this would not be in furtherance of public interest to allow this 2021 tender to proceed.
My lords, may I?
That is the point.
Yes. Now may I answer that? I can understand, my lords, as I said so at the outset. I can understand, my lords, if the court came to the conclusion that there was a substantial price escalation. There is no data before the court to come to this particular conclusion either. Now, otherwise, my lords, the principle is fairly hazardous, my lords, so far as the citizen is concerned. Your lordships have, my lords, starting from Antule's case, said that act of court should do no wrong. That is, my lords, no party should suffer on account of the fact that the list remains pending before the court. There is no portion of the blame which is apportioned to me for the delay, my lords, in this particular aspect. In which case, my lords, I, who is the highest bidder, who has bid substantially over the reserve price, is put to prejudice for no fault of my own. I can understand, my lords, if the court had said that there is a 40% price escalation, there is a 50% price escalation, or there is a 10% price escalation. There is no such finding which is returned. And please see the judgment of the division bench, my lords. The division bench effectively exercising jurisdiction under LPA, that's, my lords, effectively the first appeal against the single judge. There's nothing dealt with by the division bench. There's only, my lords, just one particular line which says that if the single judge has done this, we don't interfere, almost as if it's a 136 discretion. At least in an LPA, something should have been dealt with by the learned division bench. That's my respectful submission. Otherwise,
to the decisions of this court in so-and-so versus so-and-so and so-and-so versus so-and-so, we see no reason to interfere.
your lordship's discretion, my lords, I can't forget about that.
That is why we are referring to Cochin International and Air India.
Lordship.
These
In
two
fact,
decisions,
your lordships took a view, my lords, in Adani port,
Yes.
which I wanted to rely upon.
So that was there.
That was
not
there.
here.
I think it will pervade here as well. Lordship, please.
May I please, my lords? My lords, concurrent findings, my lords, in my favor, my lords. Grateful, my lords. My lords, stay as well, my lords. My lords, because I've been directed to allot a plot at 120 rupees per square yard, my lord.
Notice and stay.
Grateful.
My lord, in this matter, only issue is before my lord is that the married daughter is a dependent.
What about the love, affection, care of the mother towards the married daughters?
My lord,
As soon as the mother dies,
right, my lord.
they would be deprived of love, care, affection of their mother. So that is why they have been given 40,000 into and 40,000.
That has been given, my lord. But the dependency, they have given 32 lakhs more. 32 lakhs
more.
More, my lord.
About 32 lakh more. I come to page B.
My lord.
Come to page B. Where do you get this 62,000 figure, sir?
Page B, my lord.
Page B. You are proceeding absolutely on an erroneous basis, subject to we being corrected.
My lord.
That from 29 lakh, it has been raised to 62 lakh. Sorry,
my lord,
29 lakh has been increased to 32 lakh.
My lord, they have claimed 89 lakh. The tribunal has given 29 lakh 80,000 and the High Court has enhanced 32.
Please come to 23.
23, my lord. My lord.
Come to the table.
My lord.
Table shows amount claim.
My lord.
Amount awarded.
My lord.
Enhanced compensation.
My lord.
Enhanced compensation is 32,44,514.
Instead of, my lord, 2796.
That accordingly the applicants are entitled to get.
My lord, because the title has been given enhanced compensation. It is enhanced 32 lakh more, my lord.
Your SLP should have been dismissed on the ground of 500 days delay.
My lord, that's true.
Right? But we are looked into the matter on merit.
Value.
Dismissed. Passover.
The main petition is pending.
नहीं है Passover. है.
My lord, I am seeking Passover in this matter.
Passover.
Yes, my lord.
Your lordship, there is a letter any day in the next week, maybe.
Who has asked for adjournment? Respondent.
Petitioner.
No, petitioner, my lord.
Petitioner has asked for adjournment.
Yes, your lordship. Only 1 week adjournment due to personal difficulty of senior counsel. Only 1 week. Any day in the next week.
After vacation.
Please.
After vacation.
Your lordship, I'm requesting for a short accommodation in this matter.
See,
May please, madam. Well, the conviction.
He's in
and-
jail or how?
He's still in jail, madam. 5 years and 6 months, 7 years is the total.
6 months out of 7.
That's right, madam.
Sir? What do you have to say on merits?
And on the merits of the matter, madam, 3 or 4 things. One, that madam, there is a cross complaint situation, which inured.
No.
The case of the
Cross complaint has been made out by your client.
has been made out by my client.
He did the misdeed. Thereafter, the lady went and complained to her husband. Then the husband and 4 or 5 other villages came and gave you a thrashing.
That's the version that has come in the
cross complaint.
That's the version
So
that
this
comes
is
in
the
the
normal reaction that they are so agitated because a lady has been violated by you. They don't go to the police. They straight away go to your place and start thrashing you. And thereafter, you went to rest. If they have been thrashing you, you have been brutally assaulted. Your normal reaction would have been to go to the police. You did not go.
Madam, we did go. That's the case, madam. That's one. Number 2, madam, may I kindly.
Direct one don't dismiss.
Madam, may I just make 2 more submissions and then your lordships may dismiss it irrespective, madam, if that's the case. One, in the MLC, my lords, before your lordships will see there's no finding of rape.
How can it
Second,
be? She's a married lady.
That's right, madam. Madam, it's
She's a married lady. She is accustomed to relationship. So the doctor very candidly says that it's very difficult to say. But however, you found guilty because the lady's statement was, while I was easing myself, I was pushed. I found I was injured on my back and back injury was corroborated. And when she came back home, started weeping, told her husband about all these things. Husband's testimony also corroborates the victim's testimony.
as an officer of the court, since this is a legal aid matter, may I just make one more endeavor, one aspect.
One more item, yes.
On the aspect insofar as in which sequence the events transpired so far as registration of FIR is concerned, given that those complaints are not themselves on record. If your lordships will allow me a week's time to at least establish that part, because my respectful submission that may be of some relevance.
Fully argued.
Deeply obliged, madam.
Yes, my lord, I am for the respondent, my lord.
Mediation.
Failed, my lord.
Failed.
Yes, my lord, he is just offering the 10 lakhs rupees, even being serving as a government office, teacher, my lord.
Is there any possibility of a
From
union
our
between
side,
the
was
parties?
complete possibility. Because I wanted to take her back. She said, I'll go back.
3 dates she took before the mediator that I want to go back, my lords. Then she says, no, I don't want to go back. I want to separate. I said, all right, then I'm willing to offer you 10 lakh rupees. That's the most I can do because I've already paid you a sum of around 9 lakh rupees odd, my lords.
No,
1 lakh
my
rupees
lord.
your lordship's directed. I paid that also. Now, my lord, I don't know for what reason, my lord, she wants both of us to be miserable and live apart. Either they stay together, my lord, or they separate.
She has to carry on with her life with a little child.
My lord, I'm willing to
Only
pay.
10 lakh.
Your lordship may decide an amount. My lord, I'll leave it to your lordship.
No, how can we decide?
No, because he's getting an monthly salary.
We would
For nothing, he is not
want anyone to separate, but you are all mature people.
Mature.
You must come to a decision whether you would be continuing in your life or not.
Because I
It is
counseled
for
him.
you to decide.
Because he's okay either ways.
My lord,
wants to leave,
initially he offered only the 5 lakhs rupees. Even he has to pay, as per the order, my lord, about 6 lakh. Thereafter, after the convincing by all the persons, then now he agreed for 10 lakhs. Even, my lord, as per the revision petition itself, he only took the ground. See, I'm not capable to pay. He is serving as an assistant teacher, he is serving as a government officer. So, my lord, just now, even he is also having someone also.
What's your qualification?
He is now, my lord, here. He is, my lord, just for the sake of, he is working.
MA B.Ed.
Yes, my lord, but partly he worked for some time. Now she is not working.
Hesitating to say, when I put the question, what is her qualification? Why were you hesitating to say she is MA B.Ed?
No, my lord, but she is not capable, she is not mentally fit to, my lord. She is now, even what happened, my lord, during the mediation, she first decided to go, but because of his misconduct, she was beaten by the husband. She now decided not to come because she is supposed to have the threat to the life. Therefore, the reason for not coming back to.
No, I'm sorry, my lord.
Even, my lord, no notice has been issued yet in this case also. I am now
This
seeking the
is
file
GT,
to
but,
counter
my lord,
also.
It is. Yes.
My lord, no notice has been issued yet in this case.
No notice has been issued.
Yes.
You are now appearing.
Yes, my lord.
You have seen the order, 2-page order.
Yes, my lord.
Where is the decision on merits?
No decision.
My lord, I agree, my lord. Even, my
There
lord.
is no decision on merits.
Yes, my lord,
What
just.
can we do at best if you don't agree to a settlement?
It has to
You
go.
will have to send it back to the High Court to decide his revision.
My lord, whatever the my lord will quote, he agree for now for seeking the divorce. But my lord, there is a difference of amount.
You want to?
My lord, just say how he is
You are
offered
a
10 lakh
teacher.
rupees.
No, I am a teacher earning
With
50,000 rupees.
with 10 lakh, how will she survive with a child?
I'll continue to pay maintenance for the child.
Nothing.
I'm not shying away. No, I'm saying I'm earning 50,000 rupees. Whatever your lordship decide, Milord, I'm agreeable to that. Milord. I'm agreeable. And I'm continuing to pay the child. Milord.
You have been in service for how many years?
Now, Milord, 3 years. 23, Milord, I got into service. Milord. Now 3 years.
23. How old are you?
Now I'm 40, Milord, exact age, I don't know,
40.
plus 40 years. Milord.
And retirement age is 60.
60. Milord. I'll continue to pay the child. Milord. And Milord, I did not beat her. Milord, it's her own testimony before the
My lord, even
judge.
she is
Milord, that
demanding only 20 lakhs rupees fairly, my lord.
Talk to your client.
I'll talk.
She is happy with 20? She talk.
No, I'll just take instructions and get back to your lordship.
Right now?
Yes, I'll do it right
Pass
now.
over.
I'm grateful.
Deeply noted.
Lordships, the translated reports are.
Lords, before my learned friend starts, my lords may have it after at the in the last week of this month, my lords. I need to place on record certain documents, my lords, which have gone for.
The report, the district judge had submitted a report regarding the files that were not traceable. That report was before your lordships. The annexures were in vernacular, so your lordships had asked us to translate it. The report says that in respect of the 2 cases that the records of which were missing, one was actually not missing. It was actually in the record room and that had been wrongly conveyed to the, so disciplinary action was initiated against the concerned person. And in respect of the other one, reconstruction was carried out and fault has been attributed to the respective storekeepers and record keepers themselves after the detailed inquiry. That report is at page 43. That's the annexure 8. But nothing so far as anything more than meets the eye.
Counsel for the respondent's state of litigation files in court translated version of the report of the district judge Raebareli.
Yes.
Madam Nikhil and counsel appearing for the petitioner seek some time to place on record additional documents. With such additional documents, we filed by 10 days. We list on the last Wednesday before Passover.
Grateful, my
I'm obliged.
No, last Wednesday would be a holiday. Last Tuesday, 26.
26. Grateful.
Agenda as per letter.
And to respond.
24.
24, and for respond.
Yes, what is the result of mediation?
Made.
My lord, mediation has failed, my lord.
Mediation has failed.
Yes, my lord.
Transfer it.
Yes, ma'am.
Allowed, huh?
Highly obliged, my lord.
Mediation has failed, but this will not preclude the presiding officer to mediate between the parties once again. Video.
The respondent may be permitted to appear through VC.
Video.
Yes, ma'am. Grateful, Lordships.
Made, please, your lordships. I'm appearing on.
I'm very sorry.
Yes, madam.
Your lordship, I'm appearing on behalf of petitioner wife. I'm seeking transfer from Gondia, Maharashtra to Raipur, Chhattisgarh.
What about mediation? Failed? Or it has not
No,
been
no.
explored?
No, your lordship.
My lord, still the mediation has been not transferred to mediation, my lord. So I would pray.
No, no. Are you willing to be referred to mediation?
No, your lordship.
Why?
If possible, virtually, your lordship. Much obliged, your lordship.
Mediation.
It's appear for the petitioner wife, the husband sought him up. 26. Yes.
Hyderabad to Nellore.
Yes, my lord.
Mediation? Mediation
My
has
lord.
not been explored?
No, my lords. And last
Who's-
earlier round also he filed a
Oh,
divorce.
he is not appearing.
No, my lords. And in fact, he filed an application for personal presence in the last hearing. But your lordships have.
Respondent
Service
in
complete.
person,
Service complete.
service complete. He is appearing in person.
What's the last round? My lords, order dated 16.
He allowed his application, right?
Yes, my lord. 16/4/26. Your lordships have allowed.
Great. Respondent is not present. To enable him, this is version, one last opportunity is granted. Be list on next Tuesday.
Very well.
May I please move? It was not referred to mediation. She said she's ready for mediation in the transfer petition.
You are also ready? You are also ready? Yes. Very good. Mediation.
Look, this transfer petition is by wife from Nagpur to Begusarai, Bihar, my lord.
There is no counter affidavit. Appearance is there. Where is the
Service complete.
service complete? Mr. Rameshwar Prasad Goel. His name is shown?
His name is shown, my lord.
Her name is shown?
Office report says so.
Last opportunity. Same out. Next Tuesday.
Item 33, my lords, I'm seeking anticipatory bail. My lords, the grain was never in my truck only. The transporter, Naval Kishore, has given wrong information to the informant regarding truck number and in which truck the grain was. And moreover, my lords, the owner of the truck has been enlarged on bail. He's also my brother. And I'm the driver of the truck and I have not been enlarged, my lords.
Notice interim protection.
I accept notice.
Accepts notice.
My lords, no coercive step to be taken till next date.
Yes, interim protection.
I'm so grateful, my lords.
Mals, item 34, my lords, bail has been granted to the co-accused. Mals, I have mentioned all the antecedents, my lords.
You have criminal antecedents. Go to a shop with a gun and what is this?
No, my lords, but no role has been given to petitioner number 3 and 6 as per the FIR. And my lords, there is an observation that it is only simple injury. And my lords, there are 6 FIR between the same complainants and the petitioners.
Not a case of anticipatory bail.
Miles, but there is a clear observation that it is only, Miles, there is a civil dispute. We are in the possession of the land.
Don't go to somebody's shop with a gun and ask for money. And you have criminal antecedents.
Miles, but already 6 FIRs are there between the same parties.
The only problem is you don't have a clean record.
Miles, but there is no, Miles, against the petition number 1, he don't have any antecedent. He is not the accused in the FIR number 181 of 2021. That is the only antecedent. After all other FIRs are subsequent to this present FIR. Miles, we will join the investigation.
Notice interim protection.
Of which, Miles?
I accept notice, Your Lords.
Yes.
Please, Your Lordships.
This matter had come up, my lord, on the last date.
Yes.
Your Lordship had asked us to produce the original of the cancellation of that agreement. My lord, the answer is that we have not been able to find the original. The reason I'll give to Your Lordships, and then I'll move on and say, even
The original receipt?
it's not. I'll tell Your Lordship why. Please have page 252 of the paper book. This company, my lord, originally the Seths and the Mittals, they were running the company. There was a dispute between the two. On account of the dispute between the two, this record was with the Seths. Today, I am part of the Mittal group. Now, they were to hand over the record to me. Please see page 252, which records the disputes. My lord, issue here, there is a very, my lord, I'm going to show this, but let me preface it by one submission. Issue here is whether the NCLAT will have jurisdiction to examine this termination which happened in 2009 and whether it can be done in this summary fashion. My learned friend appeared last time and read the order. But reading the order will take us nowhere because I have a grievance with this order, my lord. So obviously this order is in his favor. If he reads it, it will speak in his favor. That is why I am here before your lordships. Please have one judgment, para 15, which I'll show to your lordship. But before I go there, let me show these 2 pages to your lordships. Please have this page 252 at the bottom. This is the Supreme Court order, which is heavily relied upon by the tribune, the learned NCLAT. Please have the bottom at 252.
Yes.
Whereas TFIPL, that is me, is an infrastructure development company in which the Seth group represented holds 50% shares and so and so. Whereas dispute and the Mittal group represents, it holds remaining 50% shares. Whereas disputes arose amongst the Seth group on the one hand, Mittal group on the other hand, with respect to land measuring 29 acres situated at 70. This is the same land, my lord, on the basis of which, over which the disputes arose. Now your lordship may just straight away come to page 261. Now, if your lordship will see 255, these are the terms of settlement. Now, when we are settling the monetary terms, we refer to the PAL company as one company who owes monies, etc. If we refer to it as PAL, doesn't mean that there is any relation to this controversy between us and them. This is only for the purpose of identification of the debt. That's all. Just see now page 261. The Seth group exited from the company and they were to hand over these documents to me. Now please see page 261.
Yes.
The Seth at the bottom, representations and warranties of the Seth group. The Seth group agrees and undertakes with the Mittal group as under that the shares transferred by the Seth group to Mittal group are fully paid up, free from encumbrances, agreement of sale, etc., etc., my lord. Then have 263 3.4. I'm going a little fast because this is not really relevant to the controversy in issue. 3.4 263. That on transfer of the shareholding of the Seth group held in TFIPL to the Mittal group, Surinder Seth Ashish Seth shall resign forthwith. the date of recording of this settlement, and before the Supreme Court of India from the Board of Directors. So they had to resign and leave. Then comes the books at 267, clause C4. In this process, my lord, we are no longer able to locate the original, my lord. 267, the statutory records and books of account. The State Group shall deliver all records, original land title deeds, books of accounts, etc., maintained in usual course, listed in Annexure 12, immediately on recording of the settlement by the Supreme Court, etc. So,
have the original. You may not have the original, but in 2009, if you have terminated the development agreement, why did you, in course of subsequent proceedings, not raise this?
So let me remove that impression step by step. Now, that's where I was going. First have the RERA, or please have page 290 at page 307, a RERA order of a, just kindly see 290. This is a RERA order. They are relying on an order of May, June, July 19. Please have the RERA order at 290, where the hearing takes place. Date of hearing, lower bottom of the page, date of hearing 30th April 2019. Your Lordship got it? Yes. Please straight away come to page 307.
Yes.
306 are the arguments of maximal infrastructure, that is us. Now kindly have 307 clause 3I. Clause 3I, your Lordship got clause 3I 307. In respect of the land falling in the share of Paul Industries Private Limited, the agreement regarding transfer of rights of development was cancelled in 2009. This is the public interest proceeding on which they are relying on, where subsequent statements have been made. My lord, assuming a statement has been made by some lawyer in a different context, it can't be read out of context. The core issue before your Lordship is this termination valid or invalid, or maybe even an issue whether it happened. My lord, just kindly consider, if I am entering in.
When the court referred the matter to Justice Ravindran,
yes,
did you raise this point?
Yes, yes. Now please come there. Come. That is actually, yes, yes.
Because this is a subsequent order.
Yes, yes, yes. The Supreme Court order in the reference notes that we have said that the deed has been cancelled. At page 284, that Supreme Court order, which starts at page 246.
284, where
please refer to page 284. Para 32.
Yes.
The State Group, lower half, the State Group confirms that the GPA executed in favor of Paul stands cancelled, while cancellation deed so-and-so executed by the State Group acting on behalf of the TFIPL. My lord, at that time, yes, because agreement was automatic termination. Agreement was automatic termination.
Yes.
Otherwise, my lord, just kindly consider 3 more documents and then the submission.
Yes.
Now, please have page 801, written submissions of the RP before the NCLAT. Written submission of the resolution professional. How does the resolution professional who is looking after Paul understand my case? These written submissions start from page 800, page 800 at the top. Before the Honorable National Company Law Tribunal, New Delhi. Your Lordship got that? Now, please have page 801. That on 15 January 2008, the corporate debtor entered into an agreement with the applicant to develop the project on the said land measuring 7.24 acres. In accordance with clause 3.4 of the agreement, applicant executed a general power of attorney on 20th March 8 in favor of the corporate debtor's nominee for construction and sale purposes. Further, it is pertinent to mention here that the agreement contained a termination clause under 5.2, which provided for termination in case of dishonor of post-dated checks. Pertinently, the said agreement was cancelled by Messrs. Maxwell Infrastructure Private Limited after the check dishonored. This is the RP's admission. Since the possibility of the land, since the possession of the land was not being handed over to RP, RP had moved IA number so-and-so before the Honorable Tribunal seeking possession of the land. It is submitted in terms of termination.
What basis does RP make this statement?
Because it is our case throughout that, my lord, just kindly pause and consider one more thing. Your Lordships perhaps is feeling that if we could have cancelled GPA, we could have cancelled agreement. But the point of cancelling the GPA will always be a subsequent event. After the agreement is terminated, will only the GPA be cancelled? If the agreement subsists, where is the question of cancelling a GPA? And the GPA is cancelled in 9. So therefore, if the agreement is subsisting, there is no question.
Can a GPA not be cancelled?
It
Is it
can,
necessary?
my lord,
That the
because
agreement should also be cancelled.
let me respond to that. Title of the land vests in us. We have only given them development rights. Unless they have a GPA, they can't move a square inch on that land without the GPA.
Yes, come to your next submission.
My lord, yes.
You looked at 800.
Now, clause 6, please have clause 6 at page 801.
801, 6.
6. Actually, 4, 5, and 6. 5, I have read half the amount. If your lordship will see 5.
5.
It is humbly submitted before this tribunal. In terms of termination letter dated 17 June 2009, page 66 of Maxwell affidavit dated 19/7/2009, the applicant Maximal Infrastructure offered to refund the amount received from the corporate debtor, but never returned the same. However, the applicant has also transferred the subject license to develop the subject to Parcella Real Estate Private Limited. It is humbly submitted that Resolution Professional never dispute the termination of the agreement dated 15/18. But it is the case of the RP that the termination was illegal, not in accordance with the terms and conditions of the agreement. Thus, the termination is illegal. If this is the position, the NCLAT can't go into it. It has nothing to do with the insolvency proceedings. This is a much earlier event which happened in 8, insolvency started in 19. Now, my lord, I'm going to that. Now, my lord, have the second document on which I am relying is the letter written by the Allottees Association themselves. That is at page 289 of your lordship's paper book. 289. At annexure 812. Now, when your lordship reads this, this is the Paul Allottee Welfare Association. We have 3 different associations there. Please see the registration number of this association. It is 72 of 10-11. This is registered in 11. Now, what they say, one of our association was in 19. That's a separate association. This is an association registered in 11. And this is the letter the association writes. To the Director General, Town and Country Planning, license number so-and-so, that's the same license. It is to inform your good self that an agreement dated 15/1/2008 assigning development and marketing rights in favor of Paul Infrastructure, more particularly shown in Zone Z of the sanction plan, has been terminated and power of attorney dated so-and-so has been cancelled, recalled by the licensee on 17/6/2009. Then, my lord, in the interest of public. So they are accepting the factum of termination. Now, please see the stamp at the bottom. Town and Country Planning Department has received this letter on 18th April 2016.
Yes.
Now, my lord, kindly see the 3 orders passed by the DTCP. At page 598 is the first of those orders.
The original of this 289?
That they will have, my lord. Or the DTCP will have. Your lordship may ask the DTCP.
The records in the order also. We are completely denying it. We are an association of large number of allottees.
You have
We don't
not-
even know
you have
who
not-
is- No, of course not, Milords. The allottees are here, Milords. We are registered.
What is the name of his? No, don't make these general.
No.
Don't make general statements. Who is, my lord, my friend?
Where did you get this from?
DTCP, my lord. DTCP. They have, there are different associations. Let my friend say which association he represents. Earlier, he was with the state. So therefore, all this is proxy sponsored litigation against us, my lord.
No, I'm sorry.
This is
Don't
the whole
make
point.
Allegations against me.
No, I'm not.
Preparing for the
I'm
I won that. And
I'm
in the
making.
council, there's no conflict.
I'm not saying against you.
Do not make such prejudicial comments against me.
This is a sponsored litigation against us. Now,
There is no sponsorship of the litigation. I'm fighting for the allottees.
Please see.
And they are paying my
The
material.
most important
This is
thing
extremely unfair.
in this letter are 2 dates where we find handwritten dates and interpolations. Who knows?
My lord, therefore,
After it is served in the director's office, somebody has put it.
my lord, therefore, no, but let's read the type part.
Everything is very
No, let's read the type part. my lord.
nebulous, Mr. Patwalia.
My lord, the point is, therefore, that is all the more reason why we need a proper trial. It can't be held against me. Just see two orders of the DTCP, my lord. Just see two orders of the DTCP. My lord, the point is, it needs a proper trial. This is, the NCLAT is not a substitute for all civil courts, for every kind of court. Let me play the devil's advocate. They say we have not written it. Perhaps somebody comes to a conclusion tomorrow that they have not written it. Perhaps, but what if on the other side the conclusion comes tomorrow that this does exist? My rights cannot be frustrated in this summary, short-circuited manner, my lord, is my first point before your lordships. Please see what the DTCP says and what happens to that order. Just kindly have 2 or 3 pages with me. Please have the order of the DTCP at page 598. Correct. Now, please have page 598. The order starts from page 598. Please have who has made this application and what does he want. What he has got by this order, DTCP declined him. He went to the High Court. His writ was withdrawn. That proceeding became final. Now, this is a second bite at the same cherry. Please see this now. This is Directorate of Town and Country Planning to Gangaram Professional, Resolution Professional, partner so-and-so. Request for assignment of joint development and marketing rights under the policy dated 18th February in license number so-and-so. Please find enclosed copy of the order. Now kindly turn over and I'll take your lordship straight to para 6. Or may I read the opening para 1, page 599. This is, my lord, assignment of, subject is assignment of joint development marketing rights to PDIPL for setting up society. The request for assignment of joint development and marketing right under policy dated 18th February 15 in license number so-and-so granted to TFIPL was received from Paul Infrastructure through Resolution Professional. White said representations, RP, while referring to order dated 9 December 21 of my predecessor, informed that PDIPL is not under liquidation as mentioned in para 3 and same is under insolvency. Also clarified they had submitted an application through an earlier courier, had not been received, etc. I can leave this, my lord. Kindly have para 6 or para 5. Further, in respect of assignment of JDA, my predecessor had approved in principle that matter may be forwarded to Honorable CM for granting relaxation of time period sought by the RP. However, in the meantime, representation received on 27 September, MIPL requested not to entertain the request of PDIPL received through RP for change of beneficial interest as the agreement with Paul stands terminated revoked since the year 2009 in terms of clause 5.2, 5.3, 5.4, etc. of termination agreement. This is our stand in 2022, long before we had that letter which we got in 24 for default of payment. Despite knowledge, Paul, despite knowledge, has not challenged the termination and cancellation of GPA.
See, you have got MFSI, you have got the one remedy that you can file a solicitor against although for damages and for refund of the money.
Well, that is their right. That is going to be my argument. In case termination is illegal, they could have only gone for damages. I am citing a judgment in support of that proposition. But first, my lord, your lordship may kindly have just this judgment, my lord, and 2 paragraphs of this judgment. I just want to show. This is AA Estate.
What is the fault of these home buyers?
My lord, home buyers will come late, will come at a stage. If your lordship,
ultimately they are the people who are suffering.
So my lord, therefore, we have to give 40 crores or minus 10%, 42 minus 10%. Assuming a lordship comes to the conclusion we have some right and we have a right in the property, we are willing to sit and settle with the home buyers, my lord. There is no problem about that today. But the point is, riding on their back, can we be denied of our rights in the property? My lord, just see this order, my lord. Just see the.
For that you can file civil suit.
My lord, just see.
For your money.
I will,
claim damages.
I will respond to that. Just allow me to show 2 more pages. Your lordship saw page 600. Just allow me to show 2 more pages. Page 600, just 3 paras. Para 8, kindly a para 8 with me. After hearing the party and perusal of the office record, the following facts emerge. Order dated 9 December passed by my predecessor granting in principle approval regarding assignment so-and-so. Marketing rights. Joint marketing rights were not assigned to PIDPL. Then para 3I. Consent for developer owners has also not been submitted. Further, both power of attorney and agreement executed were revocable, stand terminated in 9 and owners in terms of clause so-and-so, so-and-so. This is the finding he records. They file an appeal against that. At page 602, the appeal is rejected. I will not read that order now. Then they take it to the High Court. Please see what happens in the High Court. At page 770. First have page 694 where the prayers are there. They have withdrawn that writ petition on a statement which is not correct. I'm going to show to your lordships. 694 is the writ in the Punjab and Haryana High Court. And this writ is filed, my lord, by the RP. The same person who then comes and makes an application having failed in this process. This is not what insolvency proceedings were meant to be. Please have page 640. The writ petition is filed by the RP. And please see the prayer at page 694. Set aside the impugned order dated 14/7 passed by the additional chief secretary so-and-so, by which the request of the petition was not allowed for joint development in respect of the license. Direct the director town and country planner to transfer the beneficial interest in favor of Paul subject to payment of such fee or charges. Exactly what this order has done now. This order actually has gone a step further and asked us to deliver possession of the land also. Pass any other order. Now this writ comes up for hearing, my lord, at page 770.
Home buyers have paid them money.
The home buyers have paid more than 115 crores in
when?
2016. To the state.
No, that's not correct. That's not correct, my lord.
8 to 2010, the home buyers.
Yes. From 7th June 2008 up to 10.
Almost 18 to 20.
My lord, home buyers should not hold your lordships back. We as a company realize home buyers have come on the scene. If your lordship settles my dispute with Paul, assuming
for 18 years, their money is.
My lord, so we are not running away from this court, my lord. Your lordship can always see that.
That is why NCLT, that is why the matter has gone to NCLT and the NCLT is taking care of everyone.
No, but my lord, the NCLT has introduced Paul, which was out. If I was the one, just kindly at page 770.
Sorry, my lords. My instructions are from 2007, the home buyers are paying the money. I'm so sorry, I said 2008.
It cannot be. Development rights were conferred only on 15/1/2008, so they can't have paid in 7. My friend is wrong on the face of it. And their own pleading is that the money was the buyer builder agreement is, the first agreement is dated 7 June 2008 at page 666. My friend is wrong in his dates, my lord.
I'll show from NCLT record.
Anyway, my lord, this is a side wind. I'm not getting into this debate with him at the moment. So please see page 750, my lord. 770.
Yes.
Now, my lord, it's very interesting. I'll tell your lordship one more thing. The resolution professional, during the course of the proceedings before the NCLT, was asked to file an affidavit that what is the status of the construction. Now, status of the construction will come later. Please see that affidavit is at page 755. Please see what he says at 756, para 4. Please see that. And today he's singing a totally contrary tune. Please see 756, para 4. This is the RP's affidavit. Please see 755. Affidavit on behalf of the resolution professional in compliance of order dated 25th April 2024. 755.
Yes.
This is affidavit on behalf of the resolution professional in compliance of order dated 25th April 2024, para 4 at 756, next page. It is submitted that the corporate debtor executed an agreement dated 15 January with Triveni Ferrous Infrastructure Limited, Ferrous Alloys for granting development rights, etc. If just come 5 lines below, Pertinently, the said agreement was cancelled by Maximal Infrastructure Limited since the possession was not being handed over to the RP. The RP filed an IA, etc., etc. He has filed an affidavit that the agreement is cancelled. So, my lord, I am only submitting, my lord, this matter, your lordship may kindly examine in a little more detail. Let them file their counters. Your lordship may look into it, my lord. It's something. Now, please see the jurisdiction. Jurisdictional matter. Just give that A. Double A. Just kindly have para 15 of this judgment. I mean, it completely covers what the point I'm seeking to argue. Just pass over. Please have para 15. And after this, para 15, 1-5. Yes. According to the appellants, the termination of the development agreement dated October 16, 2005, and the supplementary agreement dated December 23, 2005 and April 9, 14 by respondent number 1 society was arbitrarily invalid and contrary to the contractual terms. It was contended that once the agreement conferred an exclusive right, I don't need to take your lordships. Now come to para 15.5. So it was a similar case where development agreement terminated. Matter was before NCLAT. And now this is what your lordship says on the jurisdiction under 65(3)(c). Para 15.5. In Gujarat Urja Vikas Nigam, this court examined the National Company Law Tribunal's jurisdiction under section 65(c) of the Insolvency and Bankruptcy Code and held that the power to restrain or set aside termination is confined to cases where, 1, the termination is solely on account of insolvency, for example, by an ipso facto clause, and such termination would inevitably result in the corporate death of the debtor by depriving it of its sole or central contract essential for the success of corporate insolvency proceedings. The court cautioned that the National Company Law Tribunal must refrain from interfering with valid contractual terminations based on breaches unrelated to insolvency. The following observation is pertinent. Given that the terms used in section 65(c) are of wide import as recognized in a consistent line of authority, we hold that the National Company Law Tribunal was empowered to restrain the appellant from terminating power purchase agreement. Our decision is premised upon a recognition of the centrality of power purchase agreement in the present case for success of the corporate insolvency process, etc. In doing so, if your lordship will come a little below, the jurisdiction, last 2 lines on the page, the jurisdiction of the, before that also, would have been empowered to set aside the termination of power purchase agreement in this case because the termination took place solely on the ground of insolvency. The jurisdiction of National Company Law Tribunal under 65(c) of the code cannot be invoked in matters where termination may take place on grounds unrelated to insolvency of the corporate debtor. Even more crucially, it cannot be invoked in the event of a legitimate termination on an ipso facto clause like Article 19(2)(1), if termination will have the effect of making certain the death of the corporate debtor. As such, in all future cases, the valid contractual terminations which would merely dilute the value and not push it to corporate death, sole contract. Now, next, 15.6 is important. The above reasoning was reiterated in Tata Consultancy, where this court held that the National Company Law's residuary jurisdiction cannot be invoked if the termination of contract arises from deficiencies or defaults independent of insolvency. Intervention is justified only when termination would make certain the corporate death of the debtor. The following paragraph is, the contract in question was terminated by the third party on an ipso facto clause, that is the fact of the insolvency itself constituted an event. Now, if your lordship will see the last 3-4 lines on this para only, the nexus with the insolvency must exist. Thus, the residuary clause cannot be invoked if termination is based on grounds unrelated to the insolvency of the corporate debtor. And then see para 15.7, where your lordships declined to interfere. Applying these principles, the termination in the present case was not occasioned by insolvency of the corporate debtor, but by persistent non-performance, letters were issued, etc. Last line, thus the termination was based on legitimate grounds unrelated to insolvency. Now, here also this will apply, my lord. This termination is not based on insolvency. This is an unrelated independent episode. So, my lord, according to me, therefore, the National Company Appellate Tribunal would not have jurisdiction to examine such a termination.
Yes.
So, my lord, and what does the tribunal relies extensively on the order of this court in contempt proceedings and in the settlement proceedings. In the settlement proceedings, first of all, I have shown to your lordship's clause where we have mentioned that the GPA was cancelled. That is specifically recorded in that settlement proceeding. Two, in the settlement proceeding, when two partners are settling, they identify a debt by calling it the dues of Paul. That does not mean that that agreement still subsists. If you want to identify, my original license was divided into 4 parts. For the purpose of identification, and we had 4 different agreements with 4 different people. If for the purpose of identification of that debt, we have referred to Paul as an entity, that does not mean that the agreement subsists. That is central to what the NCLAT holds.
Anything else?
Huh? My lord, one more order, my lord, I'll show to your lordships. Please have page 558. 558. This was an application, my lord, moved by the resolution professional before this court for a direction to the DTCP. 558. Application. This one and then this.
Same content.
7. In the same contempt proceedings, at page 557, in the same contempt proceedings, that is contempt petition number 34 of 2016, the RP had moved an application to make for certain directions to the DTCP to give him development rights, etc., etc. Then your lordship was not inclined to entertain that controversy here, so he withdrew it at page 557. So he withdrew it here. Then he approached the DTCP. The DTCP then dismissed that application. Then he goes to the High Court and withdraws the writ petition, saying that some proceedings are pending before the NCLT, whereas no such proceedings at that time were pending for this purpose before the NCLT. And then he goes to the NCLT, and then that NCLT order and the appellate order.
Yes.
May I, my lords? I'm sorry. I appear for the RP, my lords, R1 in this particular matter. My lords, right at the outset, may I take the liberty of handing over one of the orders of this honorable court?
See,
Please, my lords.
yes, is the point of your jurisdiction.
Please.
That requires consideration. So you will hear it finally.
May I respond just
Reply?
very briefly? May I respond to what's falling from your lords? It's just,
And a very important issue. And the Justice Partyawala's judgment.
my lords, that may I with greatest respect just submit this. My lords, the AA judgment that has been cited before your lordships proceeds on the premise that there is a termination, and the question in that judgment was, is the termination valid or invalid? In this present matter, my lords, what I seek to place before your lordships is that the termination itself, which for the first time this letter suddenly comes up in 24, was not even contemplated. And the reason why I say that, my lords,
In your own application,
yes,
you admitted that the agreement has been terminated.
I appreciate, I saw those lines carefully as well, my lords. My lords, those were said in the context. In fact, if your lordships were to read further down on that as well, in fact, one of the lines was, on the basis of the affidavit that I have come to know in 24 that there is a termination letter. It is only in 24 that they filed an affidavit, placed this document on record, and that's what I'm referring to over here. So as an RP, I'm between the devil and the deep blue over here. I'm saying there seems to be a case being set up, which is saying it's terminated. But according to me, it's not a termination. It's not valid in law. So I'm not acquiesced to saying that it is a termination. Be that as it may I just take one step back, my lords. I had, my lords, on the day before, I had stated, and there was some controversy whether a particular order of this honorable court had been placed on record or not. My learned friends had said, no, no, it is on record. And I, being handicapped, being online, could not controvert that. And it's a relevant judge order of this honorable court. May I just pass on this order? Please pass on 9/10/2020. In fact, unfortunately, I'll show 6 orders which have not been placed of the Honorable Supreme Court 1, but of DTCP and Haryana RERA, where they go ahead and say, we have no development rights. So when it came to them having to pay, they said, oh, we have no development rights. We have nothing left in our favor. My lords, this is an order dated 9/10/2020 of this honorable court. Also referred to in the order, in the impugned judgment. Please have,
I know.
your lordships would please have Roman 1, Mittal Group shall apply for renewal of license numbers 34, 35, 36 within a period of 2 weeks. If not applied for renewal, so I'm so sorry. I'm so sorry, my lords.
I'll file my reply. My predicament
In the
is.
meantime, status quo should
agreeing.
prevail. In the meantime, status quo should.
Can I request just one thing, my lords? My lords may keep it immediately on reopening. My lords, I'll take more than 15 minutes. I won't not take because I'll just file certain documents they've not brought on record.
My lords, in fact, what has happened in this matter, after the purported cancellation, development has been done. Lord, I bow down.
Counter by 28th. The first week of June?
Very well,
First
ma'am.
week of June.
Yes.
I'm not in the country. First
Let's
week of
can I-
July, I can come.
Can-
First week of July is also off.
The first week of July.
We are not sitting together.
I'm sorry. I have already gone, not in the country.
Rejoinder by 17th. On 22nd July.
Great.
My lords, I had filed an intervention in NCLAT and I was heard and my submissions are recorded. They've not made me a party, my lords. So my lords may
We'll
implead.
hear your intervention.
So my lords, can I have the liberty to file a short
Status quo
note?
as on today, my lord.
My lords, with
Asked
greatest
to
respect,
hand
I have
over-
to resist this.
Hand over possession, etc. my lord.
My lords,
Where is the prayer?
In the SLP.
In the civil appeal, this is appeal.
Yes. Prayer is there. Prayer is there. Huh? Page 182.
my lords, after much difficulty, the CIR process is
10
finally
one-
restarted.
One sec, my lord. 1071 is the application for stay. 1071.
1071.
Yes, my lord. Prayer is at page 1071. Grant ex parte ad interim stay of operation of the final judgment and pass any other interim order.
Where is my?
1071.
Where is the direction that you are required?
Yes,
to
yes.
hand over?
Yes. Kindly have that direct. At page 61, clause 3B.
61.
The subject land having been held to be asset of the corporate debtor, resolution professional to take control, maintain and protect the. We are in possession and control at the moment. In fact, before the NCLT, he never even wanted possession.
My
I can
lords-
show that page 814.
My lords, they are in forced possession. The possession is in fact otherwise.
The directions in para 54.
My lords, may include me as a party, my lords,
Great.
association,
My lords,
my lords, so that I
at the
can
cost-
file a note in because
At the cost of troubling your lordships on the stay.
Permitted to file counter.
very well. I'll give my my association.
My lords, at the cost of troubling your lordships on the stay aspect. My lords, with a lot of the documents also not having been placed before your lordships over here, and they're seeking an equitable order.
That they are suppressed material documents, they will have it from the court.
My lords, with great difficulty, the CIRP finally restarted, and we are at the process. The Form G has been issued.
Grateful, great.
Very grateful, my lords.
Your Lordship, I'm seeking a Passover.
Passover.
38, please.
Then,
My lord, this is
next week, my lord.
Which one?
This one, 13.
38.
38 lordships.
Lordship, the interim protection to be cut.
No, my lords.
Is there an
One.
interim protection?
My lord, this is a case of anticipatory bail, my lord, in a
Then
case.
It's Passover? Come up.
Yes,
But there is no interim
Mr.
protection.
Sanjay,
in this
we'll hear
case.
it. We'll hear it today.
Can it be tomorrow, my lord?
Very well, tomorrow.
Tomorrow.
Lordship, and the protection to be extended.
No, there's
What
no
protection? There is
at
no
all.
protection.
no order already.
There is no protection. Fresh
Yes.
matter.
30
Fresh
is
matter.
tomorrow.
You done?
Lordship, as per the order, we have to surrender this tomorrow, so that's why I'm seeking that.
2 minutes. Don't surrender
be heard.
tomorrow. First thing in the morning, it will be taken.
Please.
My lord, here your lordship will see there is a conflict between two judgments. Justice Hemant Gupta's judgment in the Punjab and Haryana High Court has not been considered at all. I've got the judgment, my lord.
Mr. Banerjee, this is 31J.
31.
So on the date, the demand notice under 13.2 was issued. What was the due amount?
10 crores and some odd, out of 50.
So
Out of
was the
50.
demand notice per se invalid on the date it was issued?
We have in our
It
petition
has to
that
be
that is
seen from
invalid.
the date of issuance of the demand notice. Cannot be.
My lord, there is a
What does the law say? This will have no application if J.
no, J is an
is fulfilled.
unconditional term. My lord, if your
So
lordship,
you are going on 31J.
I'm going on 31J. If your
So
lordship,
on the date of 13.2,
Yeah.
31J must apply.
my lord, even afterwards, if,
No.
my lord, in that event, my lord, okay, I understand your lordship's view. May I say this? 13. Let me tell you. Let me lord on the facts, my lord. Your lordship will forget the question of law for the time being.
No, it's a special petition. Unless
But-
you satisfy us on the question of
No,
law,
according to there's a conflict in judgments. My lord, may I just indicate this?
you go and pursue your
My lord,
remedies before
May,
the.
may I indicate one thing? I paid. May I indicate, my lord? Not the law. 41 to 42 crores out of 50 crores I have paid, my lord. I am willing to pay the balance. Your lordship gives me some time deposit 5 to 7 crores.
Go before the.
No, my
tribunal and
lordship
just-
gives me this liberty. I'll pay the money. Your lordship allows me to pay in 2 weeks. 2 weeks time, my lord. Because the auction is tomorrow, my lord. I can't unless your lordship allows this, my lord. I can't. Your lordship allow me to pay the balance.
Why did you come here?
No, my lord. Because of this conflict of judgments, my lord.
Dispute
No,
with, liberty to.
My lord, the
approach
auction.
the
If then your
relevant
lordship,
tribunal
the
and-
auction is tomorrow, my lord. How can I will have no remedy left. My lord.
Mr. Banerjee, if the auction is being conducted not in accordance with law, the power of the DRT under 17.3 is quite wide.
No, I'm
You
not
get
saying.
everything back.
I'm only saying this, my lord, that I have paid 42 crores out of 50. I have to pay some 8 or 9 crores. Your lordship will put me to terms. I'll pay that within 2 weeks, my lord.
No. This is the last moment you try to scuttle everything. We will not.
My lord,
permit that.
this is a difference of judgments between the two. The High Court judgment, my lord.
Sorry.
Your lordship will at least give me the liberty to apply for extension before the appropriate forum, my lord.
Yes,
For
before
payment
the
of the
balance.
balance money, your lordship gives me that liberty.
We have given you liberty to raise all the contentions before the relevant tribunal.
Very well. I'm obliged.
Next.
Because I
Let it-
apologize for the
yes.
Passover. Because High Court, while commenting,
Petition is pending before the High Court.
because that is what my case is. The High Court practically renders me a mobile vendor despite my cases that I'm a
Yours-
stationary vendor.
Your COV,
Please, my lord.
certificate of vending,
It says others, my lord.
does not say others. What is this others?
My lords, what has
What
happened
is
is
this others? The court has explained. Others
Please, my lords.
include
the local vendors.
1.1
Yes.
specifies the others category, right?
Because my whole challenge is that I am not in the others category. I am a stationary vendor, Teh Bazari holder.
Then what does your COV say?
Because the COV is absolutely wrong. That is what my submission is before the learned
You
Honorable
start
High Court.
vending on the basis of this certificate.
No, my lords.
And thereafter you say your COV
I am
is wrong.
vending on the basis of a Teh Bazari receipt since 1992. I have a better footing than a COV holder, my lords. I am a permanent Teh Bazari holder. So I am saying, my lords, this.
Why did you accept this COV?
My lords, because of the survey, everyone has to be surveyed. I am a member of the TVC.
Get it there.
My lords, may at least give me liberty to at least say that this order will not affect the merits of the writ petition, my lords.
We clarify that the impugned order, which declines to initiate proceedings for contempt, shall have no bearing when the petitioner's writ petition is finally taken up.
Deeply obliged.
Yes,
He's ready.
He can pay 15 lakh rupees.
No, don't start bargaining here again.
I'm not bargaining.
Look at her. She has to survive.
Yes, because
See, you will get married, but
No,
this
no.
poor lady will never get married. Try to understand.
may I
No,
say
no,
that?
no, let me 20.
I've already paid 9 lakh. 9 lakh rupees we've
If
already.
you don't agree, we'll dismiss your list.
Then your lordship will have to give me some time. We'll have to spread it.
You ponder over it, come back in the first week of August.
What your lordship can do is refer it back to mediation. We can draft it up for 20 lakh rupees and some time that I have to pay, make that payment in.
You make a draft, we'll keep it 7 days later.
I'll do that.
Give a copy to him.
I'll do that.
Right?
Some payment schedule.
No use sending it back to mediation. The sum, she says 20. Agree to 20, draft it in consultation with your learned friend.
I'll do that.
Get all proceedings quashed. We'll pass the order.
I'm grateful. I'll do that. I'm grateful.
List after 7 days.
I'm grateful.
But this is that. Order 7 Rule 11.
Yes, I finished, my learned friend has to do.
Yes.
I was in the companion recently. I thought not your option wanted to hear my friends first before my.
No. On the last day, Mr. Gupta was there.
Yes.
Perhaps Mr. Kumar was not there. But anyway, you start.
Yes, sir. I'm not be taking the 12 o'clock matter.
What is that?
O'clock matter.
What is that?
120. 120 was for 12 o'clock.
What is the matter about?
No, that was the matter whether 7-Eleven, a suit can be rejected on the ground of.
So one 7-Eleven be completed, then another 7-Eleven.
No, my suit has been dismissed here.
This is also a 7-Eleven. Dr. Singhvi's has been dismissed.
No, this was
rejected.
430 of the companies.
True.
But it excludes the jurisdiction of the civil.
I don't think in the second half we have a different range.
Yes.
We'll have to keep it for another.
Well, can it remain on board in the same position? That's all. For 12 o'clock.
Let us see.
Yeah.
No,
same position
at 12 o'clock. On 2 occasions, Lordship will keep it at 12 o'clock. Let the same position go.
12 baj gaya, sir.
My friend has left the court.
So let us see.
Just to retain its position.
Yeah.
That's all.
Why I'm making this request, my lord, is
Take date.
We have some different plan for next week also. It could be that if the Constitution Bench matter is over, Justice Masi will be with me for hearing out the parted matters. Your Raheja is there and some other matters are there. So we can't.
Can we do one thing, my lord? Can it just remain on board for next week in case your lordships are
In
not?
case we are there, we will.
That's right, my lord. We'll
But
take our
my
chance.
only request is it be kept for 12 because otherwise it's 120. Number is 120, then continuing on the same position as 120 is no use.
We'll get a clearer picture by tomorrow.
My lords.
Thereafter.
So your lordships are just.
We are not just now saying that it will be there next Tuesday.
And your lordships
If we-
directions to you.
I'm sitting with Justice Masi, definitely this will not be there.
Please, no.
There are too many matters which have to be. We'll
Otherwise, if that is the uncertainty, would your lordship want to have it after vacation?
If we are there in the same combination next week, it will
I
be
can
there.
just say with a certain
Sometime it
amount of
will be there.
information, I'm in the next batsman in the 9 judges. I'm going to
So
go
it
there.
will not conclude.
So the Chief Justice made it clear it must conclude by tomorrow. Because of some spillovers, I'm sure it may go for a half a day on Tuesday, but it is 100% going to conclude by Tuesday.
To get over, yes.
The Chief Justice has told us many times, and we know that it's.
Would your lordship then just keep it after vacation, Mother?
If everyone agrees, we'll keep it after vacation.
What is?
20th of July.
No. I have different anxieties.
There is only that one request with great respect, Lord. The matter is going in the NCLT. They see their order, the lordships are pending, they say we will await the judgment of the Supreme. And rightly so, because the High Court in a peculiar fashion has said, first the tribunal will decide whether he is competent to hear fraud or not. And if he comes to the conclusion, then it will go to the civil court. A parallel proceeding. Therefore, at least then give a stay, my lordship.
Your lordship has passed an order of 16th February saying that this proceeding will not come in the way of the NCLT, your lordship.
That's worse.
That's worse. That's worse.
If there is a recall of the order, at least
my
your
whole appeal will
lordship
become
may hear.
If the CB is over, Justice Masi is with me, then in that case, it will be in the week commencing 20th July. Otherwise, it will be next.
Very next.
In case it's going in July, only one request, my lord, the same 12 o'clock position, my lord, so that we'll have some kind of, that's the only request, my lord, because thrice my lords reiterated this, my lord. That's the only request.
My lord, 12 o'clock is even otherwise important.
One thing I realized, my lord, especially here, I'm not in your lordship's court, but I'm saying generally, we go climb one hill at a time. Not more than that.
As a lordship is.
Very well.
So grateful.
Lordship, you have a note with Mr. Kumar? You have any note?
Yes, my lord. But I have a list of dates, my lord. I am keeping it side by what my friend gave, and thereafter, my lord, I'll proceed with the.
Only that. So you're okay.
Second SLP.
Second SLP, sir. Second SLP is again by Madhav, sir. Same point. Madhav.
Two orders.
Two orders. One Bhatteva, one against the subsequent purchase. That's it.
Sorry, my lord.
You have another copy? No.
My lord, may I just take your lordship through this? Just only one thing that your lordship may keep in mind, only just as a prelude, my lord. Respondent number 4 was plaintiff number 1 in the suit. Is rather. Because suit is only dismissed qua me, my lord. So therefore, respondent number 4 was the mortgagee in possession under SARFACI who sought to auction the property. He has not challenged the order of dismissal of the plaint. He is plaintiff number 1. Plaintiff number 2 is a person who mortgaged the property as a guarantor for 25 crores to Axis Bank. Axis Bank assigned that property to respondent number 4, which is an asset reconstruction company. Respondent number 4 took possession of the property because the account became NPA under section 13, 4 and 14. The property was to be auctioned. At that time, the execution proceeding issued suo moto notice. And at that point of time, in the suo moto notice, he came and contested. It was rejected. He filed impleadment. It was rejected. He carried it in appeal. That was rejected. He also challenged the first order, which came to the High Court, rejected. Supreme Court rejected. Thereafter, he filed an application for setting aside the decree, compromise decree in my favor. That also was rejected. And those orders have attained finality. So one question that your lordship will keep in mind in my respectful submission is whether the plaintiff number 2 has any right in this property for him to exercise for the purpose of this plaint.
Who are you appearing for?
My lord, I am appearing for Prahars, my lord, the first
respondent 1.
Yes, my lord. May I proceed, my lord?
Yes.
So may I take your lordship to the list of dates, my lord? So, my lord, the subject property is a house built up in, my lord, in civil lines in Nagpur. 31/12/93, Income Tax Department passed an order under 269 for compulsory purchase of the subject property. This was done by the department as they found that the ATS agreement to sell, my lord, ATS is agreement to sell, between Agarwal, Jyoti and Surendra developers to be undervalued. 1994 writ petition was filed by Jyoti and Surendra developers challenging the order of 31/12/93. 21/95, the Honorable High Court in writ petition granted interim stay of proposed auction on payment of 44,39,000. 6/3/95, the Honorable High Court vacated the interim stay granted in writ petition number so and so. The page number is mentioned. Therefore, the suit property was auctioned by the Income Tax Department and exercised the powers under 269, not on 19/9/95. 21/9/95, these are not subject matter of dispute at all. These are admitted facts. Respondent number 2 was the highest bidder. Sale confirmed in favor of Riddhi, subject to writ petition number so and so. Note, writ petition was ultimately dismissed on 30/33/2015 by the Bombay High Court. And one more thing here, my lord. R2 Riddhi has since not appeared in any proceeding after the compromise of 18/4/2002. Never ever. Now, my lord, 25/196, possession of suit property given by Income Tax Department to respondent number 2 Riddhi, but sale deed was not executed due to pending writ. 27/9/96, my lord, is my agreement to sell. Riddhi executed first agreement to sell suit property in favor of R1 for rupees 70 lakhs, 65 lakhs paid and balance 5 lakhs at the time of sale deed. Therefore, more than 90% consideration was paid. 26/3/97, Riddhi fraudulently executed a second agreement to sell suit property in favor of Nimish Investment for the same property. 15/5/97, the Income Tax Department gave its no objection to the sale by Riddhi in favor of the purchaser Praharsh and thus confirmed the agreement dated 27/9/96. This is not annexure R1 to the counter affidavit. We have annexed that document. It is also noticed in the judgment of the High Court of Justice Varale, Lord, as a single judge, but when the challenge came from R4. That I will show later. 1998, Nimish Investment filed, Lord, a civil suit against R1 Praharsh and R2 Riddhi. Now, my lord, and they were, my lord, otherwise they were R1 and R2 in that suit. My lord, R1 and R2 here because they are here R1, R2. But in the suit filed by Nimish, my lord, they were R1 and my lord, Nimish was, Riddhi was R1 and I was R2. Now, the prayers here, my lord, what my friend has extracted is not right. So, therefore, it is important for me to show, my lord, what was the prayer in that suit of Nimish, which your lordship will find at page 262 or 245, either one of them. If your lordship take the paper book, my lord, because what my friend has quoted, my lord. Sorry, I'm so sorry. 245. This is, my lord, in an application filed by the respondent number 4 under order 22 rule 10 for being impleaded in the execution proceedings. This starts at 241 at 245. May I place this para 5, my lord? May I? Nimish Investment, Madhya Pradesh is now the name, filed special civil suit number on 27/298, referred to above in civil court at Nagpur against the judgment debtor, Riddhi Investment and Properties, and decree holders Praharsh. The suit was, so my lord, even R4 is calling me as a decree holder. This is R4's petition. Who is the, my lord? The mortgagee, my lord, the Sarfacey takeover company. Company. The suit was for declaration and for refund of money paid by the plaintiff to the judgment debtor under the agreement said so and so, with interest in which the following prayers were made: to declare that the defendant number 1 without any right, title or interest, dishonestly entered into an agreement of sale of the suit property with the plaintiff to direct the defendant number 1 to pay an amount of 48,09,000 as stated in particulars of claim to plaintiff, along with future interest at the rate of 24% per annum from the date of filing of the suit till its realization. The defendant number 1 permanently be restrained from executing any document of title, thereby transferring the title interest of the suit property in favor of defendant number 2, that was me. And also restrain the defendant number 1, its agents, any persons claiming through it permanently from creating third party right over the suit property till recovery of the suit claim, to saddle the cost, to grant any other relief, etc. So, my lord, the prayer was not only with reference to refund of money, as is stated by my friend in his list of dates. That's why, my lord, it was important. And R4 had all this information. R4, my lord, is the SARFACI Asset Reconstruction Company. Now, my lord, coming back to the list of dates. My lord, I have shown up to 1998, the second last one. Then 18/4/2002. Compromise decree in the civil suit. My lord, is second agreement to sell dated 26/3/97. Lord, what is written as R1 there should be R2 because it was Riddhi. Lord, R2 was me and R1 was Riddhi. So therefore, what is written here is R2 repaid to Nimish. Nimish is out of the property. R2 here, my lord. R1 in that suit. Agreement to sell dated 27/7/96 confirmed and enforced. R2 to get balance rupees 2 lakhs at the time of the sale deed. R2 will take steps to get the conveyance from the IT department. Para 9 I have quoted, not if your lordship would like to see the compromise decree, because it is mentioned in the sale deed of my learned friend. This compromise decree is very much mentioned, and he with open eyes has taken this. So therefore, if your lordship would kindly permit me to show page 150, which is the compromise decree. Page 150 it starts. My lords have it, my lord. And at page 151, my lord, in the middle of the page, filed on 27/2/98, decided on 18/4/2002, after 4 years and 2 months, compromise decree in terms of settlement. Sorry, I'm so sorry. My lord doesn't have the.
Yes.
The plaintiff and defendant 1 and 2 in the agreement dated, it should be 26/3/97, not 26/8. There is a typo there.
The order.
Executed between plaintiff and defendant number 1 is cancelled. Towards full and final settlement of the suit claim, the defendant number 1 repaid 57,50,000 to the plaintiff as detailed below. For so and so, Madhadesh is Nimish, my lord. Riddhi is, my lord, the auction purchaser from the income tax department. The amount payment is made, my lord. The last payment says 18, number 18. Today before the court, 14,50,000. For Madhadesh so and so, director so and so, the last payment of 14,50,000 is made today by demand draft bearing number so and so by Nagpur branch by the defendant number 1 to plaintiff before this honorable court. The receipt of the aforesaid entire payment acknowledged by the plaintiff. Now the plaintiff has no claim against the defendant number 1 and 2 in respect of the agreement dated 26/3/97, including suit claim. The plaintiff hereby undertakes to withdraw the criminal complaint filed by the plaintiff against the defendant. The plaintiff hereby further confirms that the plaintiff has now no claim or demand of any nature whatsoever against the defendant in respect of the said property. Now, para 5. Defendant number 1 hereby agrees and confirms that the agreement dated 27/9/96 made between defendant 1 and 2 for sale of house number so and so, with structure thereon and more particularly described in the schedule of the property annexed so and so, is valid, subsisting and binding, open the defendant
Upon the
defendant number 1. Sorry, my lord, that's a typo. And then the signatures are there, my lord. And then, my lord, defendant number 1 further confirms that out of the total consideration of 70 lakhs, it should be not 79, It's mentioned in the bracket, my lord, in word 70 lakhs. Payable by the defendant number 2, the defendant number 1 from time to time received a sum aggregating 65 lakhs. And defendant number 2 is now required to pay only the balance consideration of 5 lakhs at the time of the execution of the sale deed and on receipt of the vacant possession of the said property. 7. Defendant number 1 shall within period of 3 months from the date of this compromise shall obtain conveyance from the appropriate authority under the Income Tax Act and thereafter execute the sale deed in favor of the defendant number 2 or cause the appropriate authority to directly execute the sale deed in favor of defendant number 2. In case due to any reason the appropriate authority fails to execute sale deed as aforesaid, the time for execution of the sale deed as aforesaid in favor of the defendant shall extend automatically. So that 3-month period is given also a go by that if the authorities don't execute, then he also cannot. Now 8. If the defendant number 1 fails to execute or cause the appropriate authority to execute the conveyance in favor of defendant number 2 as set out above, defendant number 2 shall deposit the balance amount of consideration of 5 lakhs in court and shall obtain the sale deed and possession of the property through court shown in Schedule A by executing this decree. This is very important for me. Then 9. The defendant number 1 agrees and undertakes. Now there are 3 undertakings, my lord, which the Riddhi, my lord, asked respondent number 2 herein made to the court. The defendant number 1 agrees, undertakes and declares to this honorable court that its title to the suit property is clear and marketable and there is no mortgage, charge, lien, encumbrance or any third party right on the suit property. Defendant number 1 further agrees and undertakes to this honorable court that henceforth will not create any mortgage or charge or lien or any encumbrance third party right in respect to the suit property or part with possession or inducting any third party into the suit property. That's the second one. The third, defendant number 1 further agrees, undertakes and declares to this honorable court that if any claim or demand is made by anyone in respect to the said property, the defendant number 1 shall at their own cost satisfy such claims and demand and shall indemnify and keep the defendant number 2 and all persons claiming to defendant number 2 indemnified against all such claims and demands as well as costs, charges and expenses that may be incurred by them for defending such claim. 11. Defendant number 1 shall hand over the vacant and peaceful possession of said property to defendant number 2 at the time of execution of sale deed before the registrar against payment of the balance consideration of 5 lakhs or upon the tender of balance consideration. Parties hereby withdraw all allegations made by them against each other. Refund of court fee to the plaintiff in accordance with rules. In view of the aforesaid settlement between the parties as aforesaid, the suit be disposed of and compromise decree be passed on the above terms. Schedule. Now, my lord, what the order is 156 and 157. I will read just place that. Nimish Maheshwari, represented by constituted attorney so and so, is present in person. Defendant number 1 through its director, she so and so, and defendant number 2 to its authorized signatory are present. Parties are duly identified by their advocates. Plaintiffs and defendants have settled the dispute amicably out of court, and accordingly they have filed this joint compromise petition. The constituted power of attorney for the plaintiff, director of defendant number 1 and authorized signatory of defendant number 2 are present in person before me, have stated in open court that they have gone through the contents of the present petition and after going through the same, they have signed this petition. Nobody has raised any objection about its contents. All of them have stated that they agree with the contents of the same. Advocate she so and so for the plaintiff also stated at the bar that in view of the compromise between the parties, plaintiff has received a demand draft of 14,50,000. Thus, looking to these facts, I have no hesitation in accepting the contents of the compromise as the parties have given their consent for the same. As this is the application is allowed and it is read and recorded. So, my lord, order 23 requirement is completely fulfilled at 156 by identification and, my lord, by recording. Now, my lord, the next page, 157. Parties are present through their authorized power of attorney, director and authorized signatory. They are duly identified. They have compromised the matter and accordingly filed joint compromise exhibit so and so. After due verification toward both the parties have allowed the application. In view of the said compromise arrived at by the parties, the suit is finally disposed of with no orders to cause. Compromise decree as per the terms mentioned in exhibit 49 be drawn. Half court fee be refunded to plaintiff as compromise decree is asked for by the parties. And then, my lord, this happened on 18/4. At the bottom of the foot of the page, lordship will see 28/10/2002. This is when the decree was drawn up and given, my lord. So therefore, that's how, my lord, it is made. Now, my lord, may I proceed further with the list of dates? At page 3, after I had quoted all part of the compromise, 25/11/2004, that is, my lord, 2.5 years later. Riddhi again fraudulently and in breach of the solemn undertaking, which is a part of a binding decree, executed third agreement to sell in favor of the petitioner Madhav for rupees 1.22 crore. This is in breach of the undertaking in the compromise decree and therefore illegal and void. This is also hit by section 52 of the TP Act. This has been held to be so in number of orders at the instance of IAR CPL, that is R4, my lord, the Asset Reconstruction Company, and the said orders have attained finality. 4/12/2004. To come out of the compromise decree, Riddhi creates a self-serving, fabricated and unregistered MOU between R1 and R2. This is, sorry. This is all behind my back, of course. Recording satisfaction adjustment of decree. In this alleged fabricated, forged and unregistered MOU, 3 flats at Vadodara are agreed to be given to Praharsh instead of land in Nagpur. They are not given. It is only stated that they will be given after further payment of 2.67 lakh. This MOU is never recorded and certified by the executing court as required by Order 21, Rule 2, read with Section 47. Pausing here, my lord. Order 21, Rule 2 categorically says that if any decree is satisfied, it must be so recorded. And 21(3) says if it is not so recorded and satisfied, then it has no meaning in the eye of law. This has not happened here at all at any point of time, despite knowledge at the time of purchase that there was a compromise decree. All that they said was MOU, washed it away. An unregistered, unrecorded MOU which never went to court and not even pleaded, my lord, till, my lord, R4 came in, my lord, at the end. In the third petition, he said so. So, my lord, judgment debtor or Madhav Rao had 30 days to get this before executing court as per Article 125 of the Limitation Act. Order 21, Rule 2, read with Section 47 and Article 125 is a complete code for the recording, satisfaction, discharge of adjustment of a decree. 5/8/2005. R1 decree holder filed execution proceeding bearing number so and so for execution of the sale deed and delivery of possession as per the compromise decree. 30/8/2005, R1 deposited the balance of 5 lakhs in court. 2010, Income Tax Department executed sale deed in favor of R2. R2 on the same day, my lord, the same day as the Income Tax Department, executed sale deed in favor of the petitioner, again in violation of the undertaking given in the compromise decree and then again hit by Section 52, does not confer any title. My lord, these are our submissions. Now, my lord, note as per the compromise decree 18/4, Riddhi should have executed sale deed in favor of R1 as recorded in para 7, page 154 of the compromise. Defendant onward 1 shall within 3 months, my lord, I am not reading that quoted portion once again. Madhav purchased the property with full knowledge of the compromise decree. This is evident from the recitals of the sale deed in favor of Madhav at page 172. I'll come to that, my lord, and I will show that. Therefore, Madhav is a party to this fraud by Riddhi and has colluded with Riddhi with full knowledge of the binding compromise decree. 14/12. Riddhi served by the executing court, but deliberately and intentionally did not appear, and so it was proceeded ex parte in the execution proceeding number so and so. So it has never appeared, my lord, thereafter. 25/27 March 2008. Madhav, fully aware about all this and knowing that he does not have a title to the property, mortgage suit property with Axis Bank as guarantor of loan taken by another entity, Gupta Metallic, loan of 25 crores. The borrower doesn't pay the installment, the account becomes NPA. Now, my lord, there is a slight mistake here, my lord. Your lordship may kindly correct it with me, my lord, if your lordship don't mind. Axis Bank, my lord, there is a date there, 30/12/2011, which is also later on the next line. But Axis Bank assigned the debt to R4 and R4 exercised the rights under 13 and 14. What is missing is, my lord, assign the debt to R4 and R4 exercise the right. That part is missing, my lord. I'm so sorry about it. My apologies for it, my lord. And took possession of the property. Sorry, I'm so sorry. I'm not in writing. So sorry. Took possession of the subject property. Therefore, Madhav lost possession under SARFAESI and not by Prehart. That's me. Now 3012, my lord. That's mentioned once again, my lord. It's what I've already stated. Next page, my lord, at the top of the page. R4 took possession under SARFAESI. Therefore, Madhav lost possession to R4 and not to Prahar. R4 continues in possession until it is dispossessed by executing court and possession is given to Prahar, that is me, my lord, from the R4 by executing court. Note, plaintiff number 1 has accepted the orders passed by the executing court and impugned order passed by the High Court rejecting the plaint. R4 has not filed any appeal against the impugned order. The plaint by R4 therefore stands rejected. Which is what I made the first submission, my lord, with all due respect. Then, my lord, 18/7/2012, on 18/7, R4 in its capacity of secured creditor published a notice of auction in the suit property. 18/8/2012, R1 filed application in the executing court for execution of sale deed in his favor. 6/9/2012, as suit property was in possession of R4 and had issued public notice dated 18/7/2012 for auction of the suit property, executing court suo moto issued notice to R4 in the execution case. Then 11/10/2012, R4 filed reply in the executing court opposing Exhibit 26 for sale deed in favor of Prahar. Exhibit 26, my lord, is my application for execution of sale deed. So therefore, he opposed that. 30/12/2013, executing court allowed Exhibit 26. Court Nazir directed to execute sale deed in favor of R1. Prayer of possession and court receiver kept open for later. All contentions of R4 rejected. 19/9. R4 filed writ petition challenging the order dated 30/12/2013 passed by the executing court. Writ petition is dismissed. Then, my lord, 15/12/14. SLP filed by respondent number 4 dismissed by this honorable court. So, my lord, 3 ladders gone there. Now thereafter, R4 filed application Exhibit 97 under Order 22, Rule 10 for being included as party in the execution case. 16/1/2015, Court Nazir executed sale deed for suit property in favor of R1 pursuant to rejection of challenge by R4 till Supreme Court. 19/1/15, R1 filed application for possession of the suit property, that is my Exhibit 102. 21/25, R4 filed application under proviso to Order 23, Rule 3 below Exhibit 103, challenging the compromise decree dated 18/4/2002. Interestingly, my lord, in the present suit, there is no challenge to this compromise decree of 18/4/2008.
I don't need.
There is no challenge. There is no prayer. Now, my lord, 3/8/2015. Executing court rejected Exhibit 97 for impleadment filed by R4. 11/12/15. RCA filed by R4 against the order dated 3/8/15 dismissed by the District Judge Nagpur points at such and such. This order was not challenged by R4. It is held that the sale deed in favor of the petitioner Madhav is illegal and void. This has become final. Then, my lord, 2/2/16. Executing court allowed Exhibit 102, that is my application for, my lord, the purpose of possession of the property, and rejected Exhibit 103, that is my R4's application under Order 23, Rule 3, proviso, to set aside the compromise. Sale deed in favor of Madhav held to be in breach of undertaking and therefore held to be illegal and void. This order is very crucial. This order was not challenged by R4. It has become final. Then over the page. 11/2/2016, possession warrant issued by the executing court pursuant to the order dated 2/2/16. It was executed and possession of the suit property was delivered to the R1 from R4. So we got possession, my lord, of the property. I sold that property 1 year later, my lord, to R3, whom Mr. Gupta represents. 5/6/17. Petitioner and R4 filed suit number 408, contending that compromise decree dated 18/4/2002 stood satisfied by the alleged unregistered and fabricated self-serving MOU. 19/7/17, R1 filed Exhibit 20 for rejection of the plaint. R4/4/18, R3 also filed for rejection of the plaint. Trial court rejected. My lord, our civil revisions before the High Court and the impugned order, our application was allowed. And my lord, the suit dismissed qua us. My lord, the one of the contentions of theirs is, could it be only dismissed against? These are the, my lord, facts. Now, if I may be permitted, my lord, I may be permitted to first take them to the same.
Remember correctly, it was rejected on two whole grounds. One is the ground of limitation, the other is no cause of action.
Yes, please. And also, my lord, section 43 of the Transfer of Property Act, section 52 of the Transfer of Property Act, they have also been discussed, my lord. And of course, Order 21, Rule 2, and section 47 about satisfaction of the decree. Whether the decree was satisfied, whether the MOU satisfied the decree at all, my lord, and is it any satisfaction? Now, my lord, if I may take your lordship to the sale deed of my learned friend client. This is at page number, my lord.
(166) on it.
166, my lord, is the sale deed of my friend executed by Riddhi on 20/10/2005. 166. May I place this, my lord? Between so and so Riddhi and Madhav. And over the page, my lord, the history and the recital, some of the recitals will be important, which I'll place later, my lord. So, my lord, Puranics were absolutely seized of the property. Then, my lord, committed their return urban land ceiling. We are not concerned. Out two sale deeds. First sale deed was executed, registered at such and such between Poonam Agarwal, and thereafter, my lord, their other sale deed was on 1/9/1990 in favor of Savita Chandra Agarwal. And my lord, these two sale deeds happened in 1990. This Agarwal family, my lord, sold this property on. I entered into an agreement to sell the property at page 169 talks. Whereas by an agreement of sale dated 21/9/93 made between so and so and so and so, and Messrs. Jyoti and Surendra developers on the other hand, the said Poonam and Srimati agreed to sell their respective portions of the said property to Jyoti for the consideration and terms and conditions. And whereas the parties to the said agreement dated filed the necessary statement in form 37I under 269, it should be not 286 of the chapter 20C. And whereas the appropriate authority, Ahmedabad, by its order dated so and so, made under such and such.
There only one second.
Lordship, sorry. So, my lord, your lordship will find that at 169, my lord, the income tax, my lord, took the property on payment of 44 lakhs, which is mentioned on page 170. And thereafter, my lord, Jyoti and Surendra filed a writ petition challenging the order bearing number so and so passed by the appropriate, and that interim stay granted in said petition has been vacated by the Honorable Court by its order dated 6/3/95. And whereas at the auction which took place on 19/9/95 under the instruction of Chief Commissioner, the said beneficial right, title and interest in respect of the said property, which beneficial right, title, interest vested in the Income Tax Department by virtue of the said order dated 31/31/12/93. This is very important, my lord, that how Riddhi is being shown with full right, title and interest and made under so and so was knocked down in favor of the seller party for 81 lakhs. The seller party being the highest bidder was declared to be the purchaser. And whereas in pursuance of the acceptance of its bid for purchase of the property, the seller has paid the entire purchase price of so and so. And whereas the Income Tax Department had handed over vacant and peaceful possession of the said property to the seller on 25/1/96 by their letter number so and so on receipt of so and so. Now, Lord, next recital is very important for my purpose. Whereas the seller has executed an agreement to sell in favor of Praharsh, that is me, on 27/9/96 for the property of this conveyance deed for 70 lakhs, against which Praharsh was paid total of 65 lakhs. The seller has entered into an additional agreement, MOU, in connection with the said property on 17/4/2002. The seller and Praharsh, with mutual understanding, entered into an agreement on 4/12/2004 for the cancellation of an agreement to sell dated 27/9/96 and an additional agreement dated 17/4/2002, and the amount received by the seller from Praharsh has been adjusted against new property at Vadodara, and Praharsh Investment has waived all the claims and rights against the said property. Now thereafter, whereas the seller has entered into an agreement to sell with Nimish with the consent of Praharsh on 26/3 for the sale of the said property for 1,15,00,000, against which seller has received 57 lakh. Nimish filed a special civil suit in the court of so and so. Your lordships have seen the prayer of what the suit was. The same suit was settled on 18/4/2002 in the court of the second joint civil judge, senior division, and rupees 14,50,000 was paid by the seller to the Madhyadesh, formerly known as Nimish, by DD number so and so, and 43 lakhs were paid on different dates from such and such. Thus, the entire amount of 57 lakhs was paid back to Madhyadesh, and in this manner, Madhyadesh has waived all claims and rights against the property. And whereas the seller has entered into an agreement to sell with Baldao, that's another, Milord Riddhi did that, with which we are not concerned, with the consent of Praharsh on 4/4/2002. This is before the consent decree, against so and so, which was received by the seller party from Baldao, and the seller party entered into a MOU with Baldao for cancellation of the MOU to sale deed dated 4/4 on 25/11/2004, and entire amount received by the seller paid back to Baldao, and Baldao has waived their claim. And whereas the seller party entered into an agreement to sell with Madhav for the sale of the said property on such and such, and the full amount has been received as under. So, my lord, therefore we said conveyance, now my lord, just below the table, the seller party has become absolute owner of the said property by conveyance deed executed by Income Tax Department in favor of the seller bearing so and so dated 2010. Now this indenture that in pursuance of the auction in consideration of such and such paid by so and so, and seller party does hereby admit and acknowledge, and from the same every part thereof, may release and discharge the seller party in consideration of such and such paid by the purchaser to the seller party being the entire sale consideration. I don't need further note. The recitals get over here. So this acknowledges, my lord, my agreement to sell. This acknowledges the fact regarding my lord compromise decree, and then my lord adds something about some MOU, my lord, which has not been seen the light of the court till my lord 2014. Now, my lord, the next document which I request your lordships to kindly see, my lord. At page number, my lord, the application filed by R4, which is at page number, my lord. Sorry, just give me 1 second. R4, my lord, on 11/10/2012, filed reply in the execution opposing exhibit 26 for sale deed.
Page 34, additional documents, page 30.
Where is the additional document? Additional documents, my lord, filed. So lordships have, my lord, IN
149228.
149228, my lord, of 2024. 149228. 24.
Page 8 onwards. First one. Yes.
Page 8, my lord, of this IA. Page 8 of the IA number 149228. This is, my lord, filed in the executing court by R4 on, my lord, 11th October 2012.
There is another idea. These are different here.
May I place it?
This.
My lord, it says starts with the present applicant most humbly submits its para-wise reply. My lord, this is to the application of the decree holder for the relief set out hereinafter. So, my lord, to that there is a reply. If any relief is granted, it would be nothing but intervention in the jurisdiction of DRT as laid down by Mardia, though the answering is not a party to the above darkhast, merely being served the notices for adjudication. But fact remains that such manner and fashion, the instant application cannot be considered. An applicant is not at all entitled to seek any direct or indirect relief. Needless to submit at this juncture of time, applicant, but is repeated, herein moved a securitization application 86 of 2012 before DRT, which was disposed of as dismissed by the presiding officer by its order. The applicant herein have also preferred appeal against the order, and the same appeal is fixed for hearing before DRAT. The property in question, now will not kindly mark this, the property in question has been mortgaged with the present applicants under an assignment from Axis Bank. That all this while the decree holder was not at all interested to get the alleged compromise decree executed from the court, in spite of the fact that they were aware that the judgment debtor had sold the transferred property in question to Madhav. Now, my lord, I have filed, my lord, in August 2005, the sale deed to Madhav is in October 2005. And only when the present application took possession of the property in question for sale, the decree holder has expedited the proceeding before this honorable court, which makes crystal clear that the decree holder, judgment debtor, and Madhav are all hand in glove. What is he saying now, my lord? That even Madhav is hand in glove with the decree holder and the judgment debtor. It is R4's claim, which is why I wanted to show this of each other, and only and with an intention of stopping the bank reconstruction company under Securitization Act from selling the property in question, have created legal impediment.
Sir, can you take us to the plaint, sir?
Yes, sure. Yes.
Because we have to read the plaint and assess whether it calls for rejection or not.
Yes.
Why should we look into other documents?
The thing is, Lord, your lordships have also said, and order 21, order Lord 7, rule 14 also says that the documents annexed with the plaint can also be looked into.
Of course, of
for
course.
the purpose of my lord, coming to the conclusion. So, my lord, if your lordships come to my lord 200 and 351, page 351. So your lordship will mark at 351 that there are two plaintiffs.
Yes.
First plaintiff was alleging collusion against plaintiff number 2, which is what I showed to your lordship just now, before the executing court. And the defendants are Praharsh, Riddhi, and my lord, that Mr. Gupta's client, my lord, to the subsequent purchasers. May I start? 353. First is the description, my lord, of plaintiff number 1. And then the land description is there in plaintiff para 2. And then para 3, my lord, plaintiff number 2 became the owner of such and such. And thereafter, Gupta Metallics and Power had borrowed loan of 25 crore from Axis Bank. Plaintiff number 2 had given its guarantee and had further mortgaged the suit property with Axis Bank. For securing the due repayment of the said loan, Gupta had failed to defaulted in payment of the said loan, because of which its loan account was classified as NPA by Axis Bank. Axis Bank Limited, by deed of assignment dated so and so, has unconditionally and irrevocably assigned, transferred and released in favor of the present plaintiff the debt of Gupta in respect of the said loans, together with all underlying security interest and the right, title and interest of Axis Bank. The present plaintiff exercised its statutory right under the Securitization Act and took physical possession of the suit property on 17/5/2012. The present defendant number 1 has obtained the sale deed and possession of the suit property, which the plaintiff number 2 was entitled to as the owner by playing fraud. Now this, I don't want to comment just now, but there's something to be said here. The plaintiff number 1 is a secured creditor in respect of suit property. The right to relief exists in the plaintiff number 1 and 2 arising out of the same act. Series of acts and transactions and common questions of law and fact would arise in any claim made by plaintiff number 1 and plaintiff number 2. So, my lord, common questions arising here, and that plaintiff number 1 is not the appellant. The plaintiff number 1 and 2 are entitled to file the suit jointly. So this entitled.
They have alleged fraud. They have alleged fraud against you.
No, yeah, they have.
They have alleged fraud against you.
Please.
That is alleged.
Yes.
Alleged.
Yes.
So when the court is considering an application under Order 7, Rule 11,
yes,
it is to accept it as correct.
With all due respect, may I answer this, my lord, in this way? That if the fraud is alleged on the basis of a non-legal issue, because, my lord, there is a procedure in law for satisfaction of a sorry, my lord.
It's a matter of trial.
No, my lord, it would not be a matter of trial unless, my lord, there was a satisfaction of that compromise decree. Because what is being said also in that fraud is that the decree was satisfied by that MOU, and therefore the decree was given up. That is also an allegation here. Lord, what is the allegation? Let me read that to your lordship. If your lordship will kindly come to page number, my lord, straight away. My lord, the entire compromise order is quoted, my lord, from page, because the compromise and the compromise order is quoted here, right from, my lord, page number 357.
Yes.
357 onwards. The entire compromise which I read to your lordships is quoted at the foot of the page. 357, 358, 359, 360, 61, 62, 63, 64. The entire thing is there. And thereafter, my lord, what is stated at 365 para 11, 364 para 11 may now be seen. It is submitted that as considerable amount of 65 lakhs was blocked which was paid by defendant number 1 to defendant number 2, it appears that defendant number 1 was in a hurry. Therefore, before sale deed of the property was executed by the President of India in favor of defendant number 2 and defendant numbers 1 and 2, cancel the agreement of sale executed by defendant number 2 in favor of defendant number 1 by executing memorandum of understanding between defendant 1 and 2. Clause 2 of the said memorandum further refers to another memorandum of understanding executed between defendant 1 and 2 dated 17/4/2002 as additional document over and above agreement of sale dated 27/9/96 referred to in clause number 1 of MOU of 2004. It is pertinent to note that the MOU referred to in clause 2 of the memorandum dated 4/12/2004 seems to have been executed on the date of the compromise decree itself. The date of the compromise, my lord, is 18/4/2002. 2.5 years or 2 years and 8 months before. Seems to have been executed on the date of the compromise itself and is in fact referred to as a memorandum of understanding instead of compromise decree. It is submitted that clause 3 of the MOU is reproduced here in order to demonstrate that the original agreement of sale dated 27/9 and compromise decree dated 18/4 was cancelled with immediate effect by defendants 1 and 2. That clause 3 is, my lord, from the MOU. After detailed discussion between the parties of this agreement in connection to agreement to sell and MOU as per clause so and so of this agreement, it is mutually agreed between the parties of this agreement that agreement of sale and memorandum of understanding as per clauses 1 and 2 are being cancelled immediately from the moment of execution of this memorandum of understanding. Now, this is, my lord, what they are trying to say is that this happened even before the compromise decree, whereas on 4/12, my lord, is what their case is. It was executed 2004, 2 years, 8 months later. It is thus clear that the original agreement, which is referred to in MOU, stood cancelled. Thereupon, defendant 1 and 2 approached the plaintiff 2 with request that plaintiff 2 should purchase the suit property for valuable consideration and handed over Xerox copy of MOU. Defendant 1 and 2 informed plaintiff that it will be necessary to cancel the compromise decree and for that purpose they will require original memorandum. It is submitted that it appears that even though the decree dated 18/4 stood in fact cancelled on execution of the MOU, the defendant number 1 filed this SD blood that the execution application on 5/8/2005 and suppressed from the Honorable Executing Court the act of cancellation of agreement to sell and 17/4/2002 and that thereby the compromise decree dated 18/4 stood satisfied. So, my lord, they are saying about satisfaction of the decree by virtue of an MOU. Now, my lord, at 367. Because, my lord, the challenge to the compromise decree stands rejected by the executing court and right up to this court. That writ petition, Supreme Court, everything has happened. And that is, my lord, the person who was in possession of the property and who had taken over under the SARFACI. Para 30. That original MOU dated 4/12/2004 was required by the present defendant numbers 1 and 2 for producing it before learned court for taking steps for cancellation. The said reason being genuine, plaintiff number 2 on acceptance of Xerox copy of the MOU believed the representation made by the present defendant and allowed them to retain the said original and the same is in custody. So therefore, now, my lord, they are also saying that they never had the custody of it. They are admitting that they never had the original custody of the MOU. It is submitted that thereafter sale deed was executed by President of India in favor of present defendant number 2, submitted on the same day after the sale deed was executed. Defendant number 2 executed sale deed for consideration. That submitted that in view of clause 3 of the MOU, the present defendant lost any right to enforce compromise decree as against the present defendant number 2, and said rights were substituted by creation of rights in following 3 properties. And therefore, not this properties in Vadodara for a larger sum than 65 lakhs is mentioned here. This is 67 lakhs something. And the present defendant was only entitled to enforce its rights as against the above 3 properties by taking such legal steps as permissible, but was not entitled to file execution the compromise decree by filing the special darkhast on such and such. So he's saying, Lord, I could not have filed the execution. Along with the sale deed, the possession of the suit property was also delivered to the present plaintiff by the present defendant number 2. In the said sale deed is specifically mentioned, present defendant 1 and 2 with mutual understanding entered into an agreement on 4/12 for the cancellation of the sale deed. An additional agreement dated so and so, an amount received by the present defendant number 2 from the present defendant number 1 has been adjusted against new property at Barodara. The present defendant 1 thus duly waived its claim and rights against the suit property for consideration. The present defendant number 1 has already settled its claim over the suit property under the compromise decree dated 18/4 by adjusting the same against some other properties at Vadodara, and the present defendant number 1 has thus duly waived and abandoned all its claims and rights against the property. In view of the said MOU executed, the compromise decree was inexecutable, and in any fact having satisfied the present defendant number 1 had no further right to file or pursue the execution. Present defendant number 1 was duty bound to inform the Honorable Court regarding the settlement. Now, my lord, kindly have with me Order 21, Rule 2, my lord. Here. Kindly, my lord, have the CPC, my lord, Code of Civil Procedure.
43 of the SP in the appendix.
लंच के बाद
Input यहाँ पे
Order next week. W.
Lord, your lordships are keeping it tomorrow?
We do not, no, not tomorrow. Tomorrow we have a continuing part and it will continue.
In some day.
Let's do a special bench.
Whatever date next
week, my lord.
My lords,
Give a date.
1 minute. Your lordship will give a date. Very well.
my lords, may I seek kind permission to mention item 29 listed today?
I have not finished, Mr. The
Please
court
wait.
must keep, date in the order sheet. It may be next
You,
week.
you will get it not by this evening.
That's all right.
We'll have to wait till tomorrow and find out what
What
happens.
the Constitution bench?
Said about the other order 7, rule 11, it's the same thing.
Yes, it will happen.
Yes. My lord,
What I am respectfully only seeking, my lord, would it be next week or it may not be?
We can't say today.
Lordship.
We can give some indication after
Please,
tomorrow.
that's all right.
Tomorrow's court proceedings are over.
Lord, the RO record of proceedings and we'll know.
I will need something. So we will not mention only if the date is shown as 20.
Very good. You are at liberty to mention.
21st is next Thursday.
my lords,
No, 20th. My friend has a problem on 20th, not 25th.
Lord, may I mention item 31?
Lordship.
It's a group of land acquisition matters from.
No further mention.
my
Yes,
lords,
he-
my lords, one just matter, but that has been rendered infructuous. I just wanted to inform my lords, my lord.
29 will become infructuous.
Yes, but it has become infructuous.
Oh, it has become, so it can wait.
My lord, item 121, my lord, there's a joint request, my lord, for mediation.
Please. This is the review. Malas, this is the review, Malas. I have my first is of Lordship's order. We are grieved by paragraphs 214 to 217, which is retrospective application of the TET qualification, Malas, for teachers.
You are for All India Primary Teachers Federation?
Malas, state of UP, Malas. I'm on
No, which is the first matter?
State of UP is the first matter.
State of UP.
But there are a number of states, also.
You're
who were not party.
or the prospective application of the retrospective application of TET qualification for people who had already been selected as teachers.
So what? How do you construe the second proviso to 23?
Well, it's this.
Not like this, madam. You will have to decide amongst yourselves who will address us first, who will be the lead counsel, and thereafter, if somebody wants to supplement, we will definitely hear them. But not like this that one statement from here, one state from there.
The solicitor will start.
You will have to decide amongst yourselves who will address us.
Let the solicitor start first.
Yes.
Let the solicitor start. Very well. Let the solicitor.
Section 23. Malas, may I read?
I am.
Take this mic.
Of Anjuman and Nicola. Lord, I am requesting for our review petition tagged with the main petition.
Huh?
Our review petition may be tagged with the main petition.
Wait. Let us hear the others.
May I?
Yes, please.
May I start from here? I think.
Yes, of course. You are state of Uttar Pradesh.
Yes, state of Uttar Pradesh.
ये क्या change हो गया? Order?
My lords, I am appearing for the MP Association. Whenever your lordships permit,
Well, may I start?
Yes.
Well, may I place 23 for lordships? Pleasure. Any person possessing such minimum qualification as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. Malats will mark that any person possessing such minimum qualification as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment. So that is one. That does not include TET, Malats.
That does not include TET.
Malats, that comes later, Malats. That's how we would construe it, Malats, at least from my submission. 2, where a state does not have adequate institutions offering courses or training in teacher education or teaching, teachers possessing minimum qualification as laid down in subsection 1 are not available in sufficient numbers, the central government, if it deems necessary by notification, relax the minimum qualifications required for appointment as a teacher for such period not exceeding 5 years. So this is about academic qualifications. Training qualification, provided that a teacher who at the commencement of this act, so this is a proviso, does not possess minimum qualifications laid down and shall secure such minimum qualification within a period of 5 years. Then, provided further that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualification as laid down in subsection 1 shall acquire such minimum qualifications within a period of 4 years from the date of commencement of the Right to Children Free Education Amendment Act 2017. Well, that's what it says. But Malas will then come to what lordships have observed in the...
What do you make of this? Or in position as on 31st March 2015.
Malas will please come to... Malas, I'll just take Malas through that. Malas will please come to the order, Malas. I'm sorry. Will bear with me, Malas. Impugned order. And what we are aggrieved by. Well, it has page 214. May I please para 214 of the impugned, page 108.
Just tell us the para number.
Para 214.
214. Yes.
For the detailed discussions above and resting on the same, we hold that the provisions of the RTE Act have to be complied with by all schools as defined in 2N of the RTE, 2N of the RTE, except the schools established and administered by the minority, whether religious or linguistic, till such time the reference is decided and subject to the answers to the question formulated under Section 7. Logically, it would follow that in-service teachers, irrespective of their length of service, would also be required to qualify TET to continue in service. Else will thereafter, else will bear with me. However, we are mindful of the ground realities as well as the practical challenges. There are in-service teachers who were recruited, Lordship has obviously recognized that, much prior to the advent of RTE Act, and who might have put in more than 2 or even 3 decades of service. They have been imparting education to their students to the best of their ability without any serious complaint. It is not that the students who have been imparted education by have not shown in life to dislodge such teachers from service on the ground that they have not qualified the TET would seem to be a bit harsh, though we are alive to the settled legal position that operation of statute can never be seen as an evil. Bearing in mind their predicament, we invoke our Article 142 of the Constitution and direct that those teachers who have less than 5 years of service left may continue in service till they attain the age of superannuation without qualifying the TET. However, we make it clear that if any such teacher having less than aspires for promotion, he will not be considered eligible without having qualified TET. Then, this is insofar as in-service teachers recruited prior to the enactment of the RTE Act and having more than 5 years to retire on superannuation are concerned, they shall be under an obligation to qualify the TET within 2 years from the date in order to continue in service. In any of such teachers fail to qualify the TET within the time we have allowed, they shall have to quit service. We'll see the section. Lordships have said the proviso. This portion, especially which Lordships have indicated, they shall be on an obligation to qualify TET within 2 years. If any such teachers fail to qualify the TET within that time we have allowed, they shall have to quit service. They may be compulsorily retired and paid whatever terminal benefits they are entitled to. We add a rider to that, qualify for terminal benefits. Such teachers might have put in qualifying period, obviously with qualifying service. If any teacher has not put in qualifying service, well, it's this compulsory retirement and will not be entitled to continue in service. Well, it's my submission. That is not reflected directly. What Lordships has said, well, I can take my lord through the notifications and what has happened, but this does not reflect in the section as well. What my lord,
the object of the Act, Mr. Solicitor?
The object of the Act is right to education, so that obviously everybody gets
for children. For children.
For children, no doubt.
To exist for the children.
Yes, Malads. But Lordships
Don't be so self-centered.
Not at all, Malads.
That only I will be getting orders from the court protecting my service. There should be security. But we will not think about the children.
No, not at all, Malads. May I?
You have to give some meaning to the second proviso.
May I?
Please give some meaning to the second proviso.
Malads, it has to be read
The scheme of the Act, the statutory scheme was this. Initially, within 5 years, you have to. The legislature was alive to the challenge that there may not be institutions. That is why relaxation was also there.
Yes.
Right? You did not comply. No, you did not qualify the examination.
Yes.
Again, in 2017, the second proviso comes in. Why? What is the purpose of the second proviso?
Well, what Lordships have also noted at 215 is also extremely important. Malads, the entire basis what Lordships, my understanding.
Balance the interest of all the teachers.
No, my lords have also considered, and I'm saying this, Lordship genuinely also considered.
2017 gives 4 years.
Yes.
But it is with retrospective effect from 15. So you get only 2 years time. 2017 to 2019. In 2025, we are giving another 2 years time.
Yes. Well, I'm not denying it, but
so the teachers will not qualify. The teachers will have the right to continue giving the second proviso a complete go-by.
Our submission is this. Will
Mr. Solicitor and all other learned counsel, please throw some light how you overcome this second provision.
What? 23rd is.
We have kept it for open hearing
Yes.
only for this purpose.
Fellows will come to the 23rd August notification.
So, sir,
Fellows,
it's
this is in
para
pursuance. Fellows will please come to the,
Yeah, Milord.
which
Para
23rd
9
August
is
2000.
We'll have to decide one after the other.
I'm sorry, Milord.
Not that solicitor is in the midst of his argument, somebody starts.
Malas will please come to the
We'll take his
notification.
seat, we'll call upon the next.
Malas will,
Not like this. Otherwise, there's
Malas will just bear with me. This was brought into effect by the 20th, put into effect by the 23rd August notification, which is page number.
No, this is in the NCT affidavit.
This is in the NCT affidavit, page number 53.
state of UP.
Malas, it's part of the NCT affidavit. This was
In the main.
It's not in your
It's
review
20.
petition, Mr. Solicitor.
I'm sorry.
It's not in your review petition.
It's not. It's quoted. Is it quoted?
No. If it is not there, don't expect us to pick it up from anywhere.
I have
Should have annexed it to the review petition.
Maybe.
Or you should have all come with a compilation of the statutory provisions and the notifications,
Notifications, Malak.
so that, you know, we don't have to struggle to find it out.
3.1, Malas.
0.31. No, 0.19.
Would I,
You have made your point that this cannot be given retrospective effect.
And Malas will also
Very
see
good.
that it was brought into effect, Malas.
We'll note it.
The NCT notification, page 49 of,
This we can pass.
Malas will, my learned friend.
This cannot be a re-hearing of the entire matter, so let us give chance to every council.
my lord,
Right? Mr. Banerjee's submission, we are recording.
Malas, so, Malas, our submission is, it was brought into effect, Malas, in short.
Very well. This is your point.
Malas, one, and was brought into effect by that 23/8/2010, which has been interpreted by this honorable court saying that it's prospective in application. The exact, Malas, that is also, I'm just mentioning that. Arvind Kumar Yadav,
Give the citation.
Anand Kumar Yadav. Malas, that citation is 2018-13 Supreme Court cases, 560. Para 27 and para 28.
27 and
28.
Very well.
Which, that's the NCT notification which brings into effect this qualification. And that says it's prospective.
would I assist your lordships?
Can I?
Mr. Jha,
Yes,
Jha,
ma'am.
please wait for your turn.
Yes, ma'am.
Please wait for your turn. You're not here physically, you're joining through the virtual mode.
I'm grateful,
The
ma'am.
night of pre-audience, when
I'm
there are
grateful.
senior counsel who are enrolled before you in the bar.
I'm grateful, my lord.
Yes, Mr. Divedi, you're the
Yes,
senior most?
yes.
You're
No, I
the
don't.
senior most?
Seniority matters, but
No, we'll go by seniority then. We'll go by seniority as per enrollment.
yeah, we want review. Yeah.
Malas, I
Strictly go by section 23 Advocates Act.
Right. The problem is we don't know our seniority.
You don't know your seniority.
We don't know.
Well, you'll have to figure it out.
We'll just take 2 minutes time. Let me.
3 minutes, sir. We will.
Achha, 2 minutes. 3 minutes.
I'll excuse
So,
myself from.
Very
So,
good.
well,
Let
Lordship,
me-
a very short point. You should just note the point. I'll take
So the
3 or 4
point
minutes.
obvious.
Just one by one.
Yes, 3 or
Mr.
4
Bhattacharya, please wait. Let Mr. Divedi take 2. Dr. Singh with 3. Right.
So kindly have the
No, Milord.
second proviso, Milord.
Achha,
Kindly have the second proviso, Milord.
Mr. R. Divedi.
I am appearing for the state of Madhya Pradesh, Milord. Just bear in mind one fact, not that prior to the enforcement of this act in 2009 and the issuance of the notification under section 23, one by the academic authority on 23rd August 10, we had our own set of rules, Lord, and an examination also for recruiting the teachers. So everybody has, and the qualifications which are prescribed under 2000 and under section 23(1) are substantially similar as in our rules, Lord, prior to 2009. After 2010 in Madhya Pradesh, everybody has a TET. Question is of not extending this to a point of time prior to the emergence of this act itself, my lords. So I am only, my lord, attempting to draw your lordship's attention to the extension of retrospectivity prior to 2000, this emergence of this act, my lord, and the notification of 23rd August. Now, please see the second proviso.
Yes.
Provided further that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualifications as laid down under subsection 1. Please mark this expression, as laid down in subsection 1. Now this notification, therefore, this takes us back to 23.1. And 23.1, the notification has come on 23rd August 2010. So therefore, it is only, my lord, the retrospectivity can be only to the point, my lord, when the qualification was prescribed under 2010. It cannot, my lord, extend to 1998 and 1995, my lord, when the teachers were recruited. So, if after 2010, there is somebody lacking TET or other qualification, I'm assuming that TET is also qualification. That's what your lordships have observed. I'm not for the moment questioning, Lord, as far as I'm concerned. So assuming TET is there,
well, thank you.
The TET came in 2010. Before that, we were having our own examinations, Lord, and there was no TET.
Well, is my, sorry.
So therefore,
Just tell you what I have noted from your petition, State of Madhya Pradesh.
Yes, ma'am.
Education is a state subject. There existed state law prior to the coming to force of the RTE Act. RTE Act does not automatically override the state law. This is one point. Court had no occasion to examine the interplay of RTE Act with state laws. Interpretation of court does not align with the statute and rules thereunder, which never intended to apply TET to in-service teachers. SOR of RTE 2017 highlights that infrastructure was sought to strengthen the training for the untrained teachers. Intention behind including proviso can never be to apply to in-service teachers. Over 70,000 teachers.
Your lordships have rightly noted the submissions from them, but I am not pressing, I am not saying, my lord, that after 2009 our state act will continue. I am not saying that. I am not saying so. Please.
For those teachers who have been in service for more than 2 decades, 3 decades, we have provided a relaxation for them depending upon their age.
But
those who are 55 plus, they need not.
But
we have exercised our one.
With great deference, my lord, second proviso does not, my lord, require, extend, my lord, its application to those recruited earlier.
What do you mean by 31st March 2015, sir?
Lord, that has to be restricted to the notification because it says as provided in subsection 1.
Every teacher notification under 23(1) prescribes the qualifications which every teacher has to possess. Second proviso extends the time period that if you have not acquired the qualification within first 5 years, we are extending it for another 2 years. Otherwise, this proviso does not bear any meaning.
My lords, if it is not extended earlier to this point of time, 23rd August 10, it will be manifestly arbitrary, my lords.
We'll consider.
My lord, kindly just examine, my lord, if today we are required to pass the Bar Council examination after 30 years.
This argument was raised, Mr. Divedi. This argument was raised before the bench. We had the occasion to consider.
This act does not purport to repeal our state acts and rules retrospectively.
We'll consider. We are not saying we'll not consider. We'll consider.
No, it's my.
Dr. Singh, you are for whom?
I am for this entire batch of 2001, 2002, 2003.
No, in the
individuals.
Individual. What is the name of your
301.3. 300 point?
301.30.
3.1. 301.30.
Can you give the name of the party?
Amit Kumar Singh. That is, will you stop a commentary? 301.30. Amit Kumar Singh. I only have 4 dates to give a lordship. Only 4.
Very well. Amit Kumar Singh.
Yes. You should keep this compilation on the side. My 4 dates are this fellows. There was, just 4 dates, lordship will note. There were 3rd September 01 regulations.
3rd September?
01. That is almost 25 years ago.
Yes.
In this compilation at page 23 are the extant regulations on that date. I was clearly qualified under them. Please give it to my lords. Page 23. Only 4 dates and 4 documents. Well, I won't take long. And Lordship need not go into the merits of it. Just see, glance at it as to whether this is 2001 September. That table, Malas, don't go into the nitty gritty of it, but they clearly qualified under that. This is my compilation.
You said 3rd September 2000?
1.
This is not there in your compilation? Second, very well, 17 to 24.
Yes. It's the relevant parts only I'm showing Malas 22 at 23.
22 at 23.
Number 2.
Yes.
Malas, number 2. Of course, in between now comes on 1st April 2010, the Act, the RTE Act. That date is 1/4/2010.
Yes.
On 23rd of August 2010,
Yes.
a notification is issued requiring the TET. Right, Malas?
Yes.
But it has a significant exemption because they know that there are 50,000 plus teachers like this in the rural areas who don't have this qualification, who have the other one. That is relevant at 31 of this compilation.
30?
Yeah, it starts at 29. You should ignore the rest.
31.
At 31, that exemption is consciously given to protect people like me. Teachers appointed before the date of this notification. Of course, I'm in the hoary past. Even immediately before this is 2010. The following categories of teachers appointed from classes 1 to 8 prior to the date of this notification need not acquire the minimum qualification specified. Then, Malas, a particular category is A. If appointed on or after, then there's a proviso. We are not concerned with that. The third is that this exemption at page 31 is reaffirmed and reiterated at 34. That's my third point. 29th July 2011, Lordship has reached now. That is 1 year after the RTA Act.
Yes.
Justice MANMOHAN has got 34. On this date, the relevant part of this is at 34 starting, 35 is the relevant part.
Yes.
Teachers, 5A, teachers appointed after the date of this notification in certain cases, where an appropriate government or local authority or a school has issued an advertisement to initiate the process of appointment of teachers prior to the date of this notification, such appointment may be made in accordance with the NCTE regulations of 2001, which I showed to your Lordships. Conscious exemption because they didn't want to penalize people who had done to the best of their ability in the hoary past something, which was then the valid thing. Then, Malas, comes the amendment to the Act as the fourth document or the fourth point. That is at 38. 38. That is the NCTE Act amended 38 at 47 is the amendment of 12 capital A. 12 capital A. This is Malas WEF 16/2012. WEF 16/2012. Lordship, we got 12A. Justice MANMOHAN has got 12A. At 47, Malas 38 at 47. 38 at 47.
Yes.
Now, I am interested in the proviso, but your Lordship may read the whole. Power of the Council to determine minimum standards of education. For the purpose of maintaining standards of education, the Council may by regulations determine the qualification of persons who be recruited as teachers in any pre-primary, primary, upper primary, secondary, senior so-and-so, intermediate, by whatever name called, run, aided or recognized by central government. Provided, if your Lordship doesn't mind, provided that nothing in this section shall adversely affect the continuance of any person recruited in any pre-primary, primary, upper primary, senior, secondary, intermediate, or the colleges under any rule made by the central government, state government, local authority, other authority, immediately before the commencement of the so-and-so Amendment Act of 2011, solely on the ground of non-fulfillment of such qualification as may be specified, provided further that the minimum qualification referred to, etc. These are conscious statutory or delegated legislation exceptions. No, read further, provided further. Yes, provided further that the minimum qualification teacher referred to of the first proviso shall be acquired within the period specified in this act or under the right to free act, etc. Correct?
You will have to acquire it.
No, Malas, now, these are people who have been there, Malas, 50 years.
Maybe the statutory provision is that you have to acquire it. See, the problem that is arising over here, Dr. Singhvi, is precisely this.
But before this amendment.
This proviso says that even the teachers who've been appointed prior in date
Yes.
will have to get this additional
That may
qualification.
not be the right interpretation. May I
No,
explain why?
see, we have looked at it and my brother has explained it in detail.
So therefore,
We
I'm
are
trying.
looking at the act from the perspective of the child. We are saying higher education qualifications of the teachers is required because we must get the best teachers.
So, Malas,
See, unless until you get good quality education, how will the child improve?
so my answer is this.
You have to have good quality
I am
teachers.
requesting my lords to interpret it as a very strong alternative interpretation. This one which your lordship asked me to read is a proviso which will apply to those appointed after the act but before the amendment.
No, that is not so.
Before the amendment. No, Malas, because the amendment says so.
We'll
That's the
consider.
contention.
We'll
Malas, please see.
consider.
This is brought by an amendment. It's not brought by the act. Those are-
Can I have
Please oblige.
5 minutes? 5 minutes.
What Dr. Singhvi said, but after.
Just 5 minutes. Lord, kindly.
Who are you for?
I am for Milord. Point 57, Jyoti Singh. So, Milord, if your lordship had those 4 dates again, without reference to papers.
Jyoti Singh.
Yes. So, Milord, the first relevant date is 1/4/2010. That's the commencement of the act, Milord. The act of 2009 came into effect on 1/4/10. So prior to 2010, there was no real problem. On 1/4/2010, my lord, there was no TET requirement. The requirement came, my lord, on 23rd August 2010. And then, my lord, is the last date, which is, I think, 23rd of August 2017, when the second proviso, my lord, was added, which takes us back to being in position in 2015. That's, my lord, the conspectus. That's the conspectus. Now, my lord, if your lordship will be pleased to see section 23 and the notification of August 2010. Just see 23 once again, my lord.
Yes.
Any persons possessing minimum qualification is laid down by an authority authorized by the government by notification shall be eligible for appointment. So this is, my lord, prospective. Those who are going to be appointed. Then the lordship sees, my lord, the first proviso. Provided a teacher who at the commencement of this act, commencement of the act is 1/4. The commencement is not August. Whoever, my lord, at the commencement of the act, that is a person, my lord, who's already there. So there are two different, my lord, groups. Under 23(1), those who are going to be appointed henceforth, and this proviso is those who are already, my lord, in place. Those who are, I'm reading, my lord, that way, those who are teachers who are at the commencement of this act, that is, my lord, on 1/4, do not possess minimum qualifications. Under 1 shall acquire. The submission is, my lord, that people like us who were there as on 1/4, we possessed the qualification under 23(1) because there was no August. There was no TET. So to say, my lord, that we will be given a grace is wrong because the issue arose in August. So on first principles, those who were in place by virtue of, my lord, this proviso would only be required to fulfill 23(1), and 23(1) on 1/4/10 did not have TET. That's one part. Now, my lord, your lordship may have a look at the notification of August. My lord, your lordship might have it in Mr. Singhvi's compilation.
Mr. Roti has not looked at second proviso. The whole case is on second proviso, not the first proviso.
Second proviso comes in 17. I'll come to that, my lord. Please bear with me. First point I'm making is, this proviso does not apply to me.
First proviso
I am developing the first, then I will go to the notification, then I'll go. Obviously, my lord, if you just read the second, then obviously if you look at it that way, then everything is gone over. What I am trying to say is, my lord, I was not requiring any grace as on 1/4/2010. In short, I didn't require a grace. I was very much in place with the requirement of relevant qualifications as on, my lord, 1st April 2010, the first submission, without grace. Now, my lord, see,
1st April 2010,
my lord,
the qualifications had not been prescribed.
correct,
Correct?
correct.
It came into existence
August.
on 23rd August 2010.
Right.
So therefore, what the first proviso ordains is this. If you are a teacher on 1st April 2010, you are given 5 years time to acquire the qualification. From which date 5 years will count? It cannot count from 1st of April 2010 because the qualifications had not been prescribed.
Correct.
It will count from the date the qualification is prescribed. That is 23rd August 2010. You have a window of 5 years. 2015, if you don't qualify,
I understand.
2000.
Yes.
You see, that is why it is again made effective with retrospective effect.
I submit.
You are given 2 years time. 5 plus 2.
I am only saying, my lord, that the first proviso talks about commencement of the act.
Mr. Roti, my brother has been very benevolent in giving you some extra time. I was telling him, let the statute operate as it is. And we had a long discussion on this.
So one more argument. One more argument.
He's been very, very benevolent.
Now, one more argument, my lord, which is based on what your lordships gave me in the order. Kindly turn to the order. Let me read the order first, my lord, and then make the submission. Kindly turn to para 168. 168 of your lordship's judgment.
Paragraph 168.
Yes. NCT 168. The argument is this, my lord. In other words, that the requirement of TET is only for those who were appointed post August 2010. In that light, we were exempt in 2010. My lords will remember, we were exempt under 2010. Can I just show that and then read 168? 168 is completely in my favor. May I read 160?
Read it, but just answer one question.
Yeah.
The requirement gets incorporated on 1st August 2010.
Sorry?
The requirement gets incorporated.
Yes,
on 1st
absolutely right.
So there can be no recruitment after 1st August 2010.
Without that.
If your submission is accepted, then the second proviso will have no relevance. It should never have been there.
So what I am
Therefore, Mr. Rodki, you're missing the point. The point is of what is the significance of second proviso?
Without second proviso does not specifically say that the exemption granted in 2010 is gone.
Who are in position on 31st March
Of course.
2015, they will have to acquire it.
Mr. Rochi,
So by
the teachers have to upgrade their skills.
Achha,
They have the best standards for the teachers. Examine it from the
I've
student's
seen,
point.
no, I've seen.
Let them have the best
I am
teachers.
seeing which way the wind is blowing. So I won't put it another way. I just want to read 168.
Okay.
This is not in my favor. That's why I'm reading it. Para 168. NCT's notification reinforces this requirement by stating that teachers working in unaided schools or those in position as on 31st March 15, like me, my lord, must qualify TET. Now, next para is important. The language of both the RT and the notification leave no room for ambiguity that even those who are appointed prior to RT, like me, if not qualified, must not be TET against me within the grace. Now, look at the next line. Only those appointed prior to so-and-so in accordance with those applicable rules or covered by specific exemptions. This is in the notification of 2010 are exempt.
Exempted, but thereafter 17 does not grant you that exemption.
If you are
This is the difficulty.
you are exempted and then you take what you give
Well,
by the left
yes,
hand, you take it away by the right.
Yes.
What happened?
Just add one line.
Yes, yes.
You had your fill.
Mr. Gupta, you were there.
You had your fill in the previous round. How many days we heard you?
May I remind you a lot?
5 days.
He should not be stopped,
No, not a,
No, my
but
lord.
Mr. Gupta will hear you because there are other people.
If your lordship is going by seniority, my lord, then Mr. Bikash Bhattacharya should be heard first. Then me, then my lord,
then
the
the
rest.
others.
Yes.
Very well. We'll go by seniority.
I will keep myself confined specific to the question of Milord 23
proviso, second proviso.
Second proviso, yes.
May I read it, my lord?
Mr. Bhattacharya for whom?
19, and 39. And 2325.
Now just give the
19.
first party's name.
Vidhan Kumar Mondol.
Vidhan Mondol. Vidhan Kumar Mondol. Right.
And Shamoli Haldar.
And Shamoli Haldar.
0.31 Shamoli Haldar.
Rashmi.
Sonali Chaudhary. And foreign three names.
Vidhan Kumar Mondol. These are separate review petitions.
Yes, madam. Three.
Shamoli and the last one?
Sonali Chaudhary.
Sonali. Very well. Yes, Mr. Bhattacharya.
The my lord, section 23, my lord, should be read in its entirety.
Right.
Yes. Now, my lord, the first is, my lord, the Act desires that there should be a prescribed qualification by competent authority. And then say that any person possessing such minimum qualifications as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as teacher. This is the prospective in operation. Now, second is where state does not have any adequate infrastructure, they will be given 5 years time. Then let's second, provided the first proviso. A teacher who at the commencement of this act does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years. And then second proviso, provided further, this is important, Lord, we are governed by this, that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualifications within a period of 4 years from the date of commencement of the Right to Children Education Act. Now, our appointment was, my lord, at a point of time when, my lord, the academic qualification was, my lord, determined by the NCTE. And my lord will kindly turn to, my lord, the
regulation.
In the matter of, my lord, ANJUMAN Vidhan. Lord, kindly turn to, my lord, page 155.
What is that? What is that 155?
155 is the NCTE, my lord, regulation, notification.
Dated?
Dated 23rd of August.
23rd August 2010.
Yes.
Very well. Yes.
Now, my lord, here, my lord, we'll find, my lord, details are given, then kindly come to, my lord, at page 157.
You just refer to the regulation number?
Yes.
Because we are looking at this compilation.
The regulation 4. Regulation 4 of.
Regulation 4.
Yes. Of 23rd August 2010 regulation.
Regulation
Notification.
Notifications.
2010 notification.
Teacher appointed before the date of this notification?
Yes.
Is that the marginal note?
Yes. Teacher appointed before the date of this
notification. Yes.
The following categories of teachers appointed to class 1 to 8 prior to date of this notification need not acquire the minimum qualifications specified in paragraph 1 above.
Right.
A teacher appointed on or after 3rd of September 2001, that is the date on which NCT determination so-and-so regulation 2001, as amended from time to time, came into force in accordance with the regulation. And, my lord, we are all governed by these. Then, my lord, TET was not at all, my lord, a qualification necessary for the purpose of recruitment teacher, but we had, my lord, different training, not TET. Then, my lord, kindly turn to, provided that a teacher of class 1 to 5 possessing B.Ed qualification or a teacher possessing B.Ed special, my lord, this is not relevant.
2001 regulation.
Then, my lord, will kindly take the trouble to turn to page 163.
Good to hear Bengali in court again.
I'm grateful.
That is the inherent resource. Kindly turn to, my lord, page 163. That will also, my lord, clarify the position.
This is what?
29th of July.
29 July 2011.
Yes.
Yes, 29 July 2011.
Yes.
Which clause?
My lord, kindly turn to, my lord, clause 5. Rather, para 5.
July 2011. Yes, para 5.
For para 5 of the principal notification, the following shall be substituted, namely, teacher appointed after the date of this notification, in certain cases, where an appropriate government or local authority or school has issued an advertisement to initiate the process of appointment of teachers prior to the date of this notification, such appointments may be made in accordance with the NCT Determination Regulation 2001. Therefore, it's very clear that the NCT had the basic conception in the mind that prior to 2001, the TET qualification was not available, it's not necessary. Then let B, the minimum qualification norms referred to in this notification apply to teachers of language, so and so for different languages. Now, basic thing, Milord, that even in 2011, the NCT found that 2001 regulation appointments did not come within the scope of TET. That is one important thing.
2001
And
regulation.
if your Lordship kindly comes, 2001 regulation, Lordship will be pleased to find.
Page number 142.
137.
Let's turn to page 137.
2001 regulation.
What is that?
That is the Milord, the
3rd September.
3rd September.
সবাই মিলে কথা বললে কোর্ট হবে কি করে?
3rd September 2001.
This is the Milord, the qualification regulations may be called National Council for Teachers Education Determination of Minimum Qualifications for Recruitment of Teachers in School Regulations.
So you are referring to which particular regulation?
Milord, kindly see that your Lordship will not find TET mentioned.
No. Of course, 2001, TET was introduced only after the RTE Act.
Right so.
So 2001, TET was unknown.
What I
It was unknown.
That's why Milord, these notifications will give exemption to the teachers who were appointed, Milord, prior to the knowledge of TET.
Very well.
And this exemption, Milord, was considered by your Lordship. Kindly turn to Milord, my Lord's own judgment.
Yes.
Para 168.
That has been placed just now by Mr.
Yes, may I just repeat? Kindly, page, para 168 is very important.
Page 90.
Page 90. Well, I will read it a little slowly for my benefit. Milord, I would rather read 167 to Milord, my Lord's reasoning to arrive at 168. Importantly, the first and second proviso to section 23(2) of the RT Act carve out a transitional obligation for in-service teachers who did not possess the minimum qualifications at the time of commencement of the Act. They were required to acquire such qualification, including passing TET within a prescribed time frame. The second proviso introduced by the RT Act extended this compliance period by a period of 4 years from the date so-and-so. The express legislative intent was to bring in all service teachers within the ambit of uniform quality of standards. Then, NCT's notification also reinforces this requirement by stating that the teachers working in unaided private schools, or those already in position on 31st of March 2015, must qualify the TET with the stipulated period. The language of both RT and the notification leaves no room for ambiguity that even those teachers appointed prior to RT, if not qualified, well, this is important, if not qualified, must meet the TET requirement within the grace period. Only those appointed prior to 3rd September 2001 in accordance with the applicable recruitment rules or those covered by specific exceptions were exempted. Milord, this is the finding of the Honorable Court, which Milord really supports my cause. But Milord, this is my misfortune, but in the direction portion,
this is just noticing the relevant statutory provisions and ultimately 23 subsection 2 second proviso, pins you down.
The second proviso pins me down. I have no quarrel, but that will not empower the.
Because whatever exemption is given under a notification cannot override the statutory provision.
My Lord,
NCT cannot grant an exemption which the legislature is not providing. The will of the people has to be respected, Mr. Bhattacharya.
The deepest of respect, Lord, I just, Lord.
Right? And you are expressing the will of the people.
I am.
Presently.
Now, I am trying to point out, Lord, that the statute says it depends upon the academic authority. It depends on the academic authority.
We will consider.
The academic authority felt it. academically felt it that these people need not go to TET.
Very well.
But I can also not concede to the extent that if the court feels that they should upgrade their skill, let them do it. But that should not be coterminous with their recruitment. That would be too atrocious.
Very well. Thank you.
Lordship,
I have-
give the
Mr.
same
Gupta, I have
benefit that is given to the others, that you may not get promotion.
Very well.
But you,
I'll just
have to
state the
go
two
with it.
submissions. First of all,
Who are you appearing for now?
Milord, State of Tamil Nadu,
You're still
same,
written by State
yes,
of Tamil
yes.
Nadu. Very well.
and Milord,
Because we have been hearing from the morning
yes,
adjournments because
Change
there
of
will be a
guard.
new
Milord,
new.
your Lordship is not going to adjourn this matter, Milord, so we better be here. Now, Milord, I appear in 14 matters, Milord, but the list is there, I don't have to
Very
give
well.
it.
First State of Madras.
First State of Tamil Nadu.
State of Tamil Nadu.
2 points, Milord.
Yes.
By directing compulsory retirement, your Lordship has interpreted the second proviso in such a way that it introduces an eligibility condition decades after the person went into service. Now, even though this may be for the benefit of the students, it goes against a very fundamental principle of service law, which also must be applied. That's my first submission.
May I take
Second, my lord.
May I take leave?
Second thing is this, my lord. We have given the facts. For 4,49,850 teachers in total in the government in my lord, Tamil Nadu. 3,28,701 not qualified under TET. In 2 years' time that your lordship has given us, my lord, it is administratively impossible to repopulate, my lord, the entirety of the service.
Statute gave you 2 years in 2017.
My lord,
We have given 2 years in 2025.
no, my lord, no, my lord.
If your teachers do not equip themselves, Mr. Gupta, we wouldn't expect the state of Tamil Nadu to
my lord, would your lordship, my lord,
come
kindly,
forward on behalf of the teachers.
no,
By now, there may be several lakhs
my lord,
of
just
teachers.
kindly permit me to end my submission.
Right.
The difficulty is, my lord, if it's administratively impossible to repopulate the service, my lord, then the schools have to be shut down. That's what I'm trying to say, my lord. And my lord, your lordship's help,
What happened in 2017 when this notification came?
it wasn't interpreted to mean what your lordship has now said.
It is
Your
very
lordship has
clear.
interpreted
is
it for the
very
first time.
clear. It is very clear.
It may be, my lord,
It
clear
is
to
very
your
clear,
lordship, my lord.
required no interpretation, but the court is forced upon
However,
to interpret a plain and simple statutory provision.
all I'm saying, my lord, is kindly give us at least 4 years' time. Otherwise, administratively, my lord, it is impossible and the schools will have to shut down. My lord, this is in grounds 4 and 5 of my review, my lord.
4 years' time.
Yes, my lord.
We'll keep in mind.
Lordship.
Yes, Mr. Patel.
I am for the teachers in the state of Jharkhand.
Acha,
We have-
just 1 minute.
Sorry.
What is the cause title of your petition?
Cause title is, my lord, Akhil Jharkhand Prathmik Shiksha Sangh.
Akhil?
Akhil Jharkhand Prathmik Shiksha Sangh. It is
Akhil
301.2.
Phone number mein hai.
Point 2. We are teachers, my lord.
Acha. Akhil Jharkhand Prathmik Shikshak Sangh, Jharkhand.
Correct.
You have raised 7 points.
Correct.
Oversight of NCT notification which exempted pre-2010 appointees from writing.
I am
test.
starting from
First, court misconstrued RTE Act 17. Intent was never to retrospectively impose TET on teachers appointed prior to 10. Executive clarification dated 3rd August 17 to the effect that teachers appointed prior to 2010 need not acquire this qualification. Rule 9 of RT amendment rules violated. Our interpretation has violated rules very well.
Yes,
Pre-2010, this is what we have culled out from your petition.
Correct.
treating pre-2010 appointees with post-2010 appointees amounts to hostile discrimination, violation of 14. Sixth, appointees fulfill the eligibility conditions when they were appointed under the relevant state rules. This is the common submission. And new promotion rules 2025 of the state has granted exemption. So state law will override a central law.
So, my lord, I am not going to argue all that.
So which one will you argue? Tell us out of these 7?
My lord, the point I am essentially placing before your lordships is that your lordship's judgment now, as my learned friend Jaideep just said, your lordships are virtually imposing a new condition of eligibility by a judicial interpretation, which if possibly the executive had done by a service rule, may have been liable to being struck down by your lordships. And realizing this, my lord, one line of the 2010 notification has been probably overlooked or missed. Please see page 42. We are people who were recruited from 91 to...
You are referring to which regulation?
Yes, please see page 4. I am referring...
No, we are not looking into every petition because
31st,
there are more than 100 petitions. It's absolutely impossible to have 100 petitions.
31st March 2010 notification prescribing the qualification.
31st March 2010. It's not in this compilation. You have a copy.
In your lordship's judgment, I only have a soft copy. In the judgment at page 41, it is reproduced.
Page 41.
41.
Page 40. Just give the paragraph number.
Para 62.
Para 60.
The reference comes from para 61. This is under that heading where acts and notifications where your lordship have done. Now, please see para 61. Your lordships have said central government notification dated 31st March 10 appointed NCTE as the academic authority. Then thereafter, the 23rd August 2010 laid down minimum qualification. This is what I am reading. Please have the next page, para 4. Teachers appointed before the date of this notification. The following categories of teachers appointed for classes 1 to 7 prior to the date of this notification, we are that class, need not acquire the minimum qualification specified in para 1 above, and C, a teacher appointed before 3rd September 2001 in accordance with the prevalent recruitment rules.
Right.
Now, my lord, this recognizes a very established principle of service jurisprudence which says that your conditions for eligibility for appointment, your lordships have subsequently said promotion will be included in appointment. I have no quarrel with that. Perhaps I may not be able to get promoted till I acquire the TET qualification. But the question is, would my original appointment be also under jeopardy on account of a qualification which is laid almost a decade after or 2 decades after I have come in? And according to me, my lord, the central government has saved us under para 4 subclause C. And once...
Some notification says prior to the statutory amendment. Statutory amendment has not been challenged. That is of 2017.
That is the fresh notification.
Look at para 69 of the judgment.
Correct.
The executive has written a letter.
Correct.
Just turn to para 69.
Yes.
The order, please read it.
I'm reading it.
Yes.
On 3rd August 2017, the Additional Secretary, Ministry of Human Resource Development, Department of School Education and Literacy issued a letter to the state secretaries reminding them that the last date to acquire minimum qualification is 1st April 2019 and no teacher who did not possess the qualifications under the RTE Act would be permitted to continue. So, my lord, this would have to be read.
My brother has been more than benevolent.
This has been informed as far back as on 17.
I do understand.
Therefore, the executive stand was also this before us, that this qualification is mandatory. It had to be acquired within 2 years of 2017. My brother has said not required for people.
I do realize, my lord, I was
within 5 years. Then even till 5 years, you got it in the next 2 years.
My submission is
extension of time.
My submission is that if we are exempted under the basic notification, all subsequent statutory regime will not come.
But that notification has to yield to the law.
You're not looking at this statutory amendment of the Act.
Statutory amendment.
Well, then that will relate back to this Act itself. It will not cover a person.
Amendment, if it had not had those words 3rd March or 31st March 2015, we could have interpreted it otherwise. We have put these review petitions only to get assistance from you. How do we interpret the second proviso in a manner different from the one in which we have interpreted?
My reading is that if a person is already excluded from this whole new statutory framework, then any subsequent amendment or proviso will not bring him in, my lord. That's all that I'm trying to say.
That's the next in seniority,
I go in.
Mr. Giri.
Yes.
Very grateful, Lord.
301.8.
What is the name of your client?
Meghraj Singh and others.
Devrat Singh. Madam, dekho to.
My lord, the cost title starts from page 111.
Just one.
What he says.
Devrat Meghraj Singh.
Yes, my lord.
Meghraj Singh.
My lord, altogether 232 petitioners.
Deprivation of livelihood, retrospective application is irrational. Education is a state subject. State laws predate RTE. Education is a concurrent subject, the state subject. Of notification dated 23rd August 2010 exempted teachers appointed prior to the notification. Proviso to 23(2) provides for acquiring minimum qualifications within 4 years for teachers appointed prior to coming into force. That was not a minimum qualification. These are the grounds that.
These are the grounds. My lord, they have been argued in one way or the other.
It has
Right.
been argued.
And therefore, my lord, why should I
Yes.
take up your lordship's time on that?
Right.
But please come to the section.
Yes.
Because
please.
this is where your lordship seeks some.
Please, we want
Some
assistance on 23
Yes.
to second proviso.
My lord, this is something, my lord, which I am advancing before your lordships. Because this is a manner in which if it is read in this manner, probably many of us come out of the net as such. Please come to section 23 once more.
Yes, we are on 23.
My lord, this was there right from the beginning. That is from 1/4/2010 onwards. Any person possessing such minimum qualifications as laid down by an academic authority. Academic authority, my lord, is also subsequently defined
As NCT.
as NCT. Authorized by the central government by notification shall be eligible for appointment of a teacher as a teacher. My lord, subsection 2 may not strictly apply, but for the sake of completion, let me just read it. Where a state does not have the adequate institutions offering courses or training in education or teachers possessing minimum qualifications as laid down under subsection 1 are not available in sufficient numbers, the central government may, if it deems necessary by notification, relax the minimum qualifications required for appointment as a teacher for such period not exceeding 5 years, as may be specified in the notification. My lord, the second proviso was not there. Probably addition of this or bringing in a qualification, my lord, post prescription of the qualification as per a notification dated 23/10/2010 might have been ultra wise. But your lordships are right. There is a substantive plenary amendment. Provided that a teacher who at the commencement of this act does not possess minimum qualifications as laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years. Suppose we stop with that. Then also, my lord, all those persons, these 232 persons, like several others, they were all appointed prior to 23/10/2010. They were appointed prior to 1/4/2010. There were many of them are appointed in 2001 and up to 2009. Therefore, my lord, the first proviso also does not hit them in that way.
No, it hit them. They did not realize it. Because they were teachers. It says provided that a teacher,
Yes.
not a person. Person is referred to in 23(1).
Yes.
First proviso does not refer to person.
Yes.
It says provided that a teacher
Yes, my lord.
who at the commencement of this act, that means 1st of April 2010,
Yes.
your client is a teacher
Yes.
and does not possess the minimum qualification under 23(1)
Yes.
shall acquire such qualification within a period of 5 years.
That's right.
So you are a teacher in position on 1st April 10. You are given 5 years time to qualify.
My lord, the minimum qualifications laid down in the subsection 1 is by means of a notification.
Right. So
Insofar as the first proviso
that comes on 23rd August 2010.
That's right.
Right? So 5 years cannot be counted from 1st of April. 5 years will obviously have to be counted from the date of the notification.
Correct, my lord. No,
So you are a teacher.
no, my submission is this, my lord. My lord, first proviso therefore says, possesses minimum, sorry.
Qualification, the minimum qualification prescribed is
First proviso therefore says, who at the commencement of this act does not possess as laid down under subsection 1. Now, who lays down under subsection 1? As per a notification. The notification under subsection 1, which has actually continued to remain from 2010 till date, is a notification dated 23/8/2010. Lord, what your lordships have seen,
These were people who were exempted.
Yeah, that also covers.
yes, no, my lord. My lord, the 23/8/2010 notification will have to be read into subsection 1. Because subsection 1 contemplates that there has to be a prescription in terms of a notification. If you read the notification dated 23/8/2010 into subsection 1, section 23(1), then first proviso would also draw sustenance from that.
First proviso may draw sustenance, but the problem is the first proviso uses the expression commencement of this act.
Yes.
Commencement of this act is 1st April 2010,
Yes.
not 1st August 2010.
No.
So therefore, the qualification which is prescribed on 1st April will have to be met by the first proviso. The second proviso is talking about the cutoff date as 31st March 2015.
Can I come
By
to
that time, this
I'll come to the-
NET qualification has come in.
I'll
TET
come to the
qualification has come in.
I'll come to the second proviso in a moment, my lord, because I made this submission and my lords felt, I am also hit by subsection, the first proviso.
Both 1, 2.
That's right. Therefore, insofar as 1 is concerned, please read the 23/8/2010 notification into subsection 1 and please have a look at the notification. It's not a question of exemption. Prescription comes under the 23/8/2010.
The second proviso is a complete knockout punch.
No, Lord, I'll come to that.
No, you don't forget the background. You're on the background.
Lord, I'll come out. I'll come to the second proviso in a moment.
The second proviso, right?
I'm anyway tottering on the ropes. Therefore, my lord, let me come to the second proviso. In a moment.
Other council.
I'll just take a minute. I'll just take a minute. I understand, my lord. I'll just take a minute. The notification dated 23/8/2000. This is my submission.
Yes.
Notification dated 23/8/2010 will have to be read into subsection 1. It has to be read into the proviso also. When your lordships read the notification, your lordships will have to, because the prescription contained for minimum qualification in the 23/8/2010, this is where TTE comes in, comes about under the 23/8/2010. There is no plenary statute prescription for TTE, nowhere. And then when your lordships come to clause 4, training to be undergone, clause 3, then clause 4, this is also a prescription, not an exemption. The following categories of teachers appointed for classes 1 to 8 prior to the date of this notification need not acquire the minimum qualification specified in para 1 above. And then, my lord, the prescription comes about. Lord, is it to be construed as an exemption? Because where does 23(1) says exemption? 23(1) says prescription. And prescription would include whatever is mentioned in clause 4. If the prescription contained in clause 4 is...
Was NCT conferred any power to grant exemption?
Lord, if it is not...
How could NCT grant exemption? Being a delegated authority?
No, my lord, if
it could not have granted. It could not have granted.
And therefore, my lord...
the parliament, in its wisdom, thought that it is better to make it absolutely clear. Second proviso is inserted with effect from 2017, requiring every teacher in position on 31st March to possess this qualification.
Please come to the second proviso then.
Please read it.
Yes. Provided further that every teacher appointed, my lord, would it mean appointed in terms of the provisions of the Act? Because the Act does not have any retroactive operation. It cannot go beyond 1/4/2010.
Or in position as
on the 31st.
Position means not appointed under this act.
No.
Maybe prior to
the act.
My lord, as in or on.
Please,
My lord,
Mr. Giri, we are pointing out. Look at it from the perspective of a child. He needs a good teacher. He needs good quality education. if the teachers are lacking in education, how will they be able to teach the next generation? We have looked at it from this perspective. That's what my brother,
and
we
our
must tell you, when
Lordships
we
are
are,
bound to. Lordships are bound to look at the holistic picture. We may not be, but I understand, my lord, therefore, what your lordships are having in mind. But appointed means appointed in terms of the act. But can the words which come after that, in position on the 31st of March 2015, would it take in persons who were appointed prior to 1/4/2010?
We'll consider.
Who does not possess, yes, my lord, just one moment, my lord. Who does not possess minimum qualifications as laid down under subsection 1. And therefore, my lord, please read the notification again as part of subsection 1. If your lordships are pleased to read it that way, then the qualification that we possessed, which is treated as qualification in terms of the clause 4 of the notification dated 23/8/2010, will have to be treated as sufficient for the purpose of proviso 1 and proviso 2.
Very good. Thank you.
My lord, this is what we wanted to say.
Yes,
My lord,
Mr. Jha. We believe you are next in seniority.
Lord, there is.
Mr. Khurshid, you came just now. They have been waiting for some time.
Yes. Lord, can I?
I'm
30 seconds, my lord.
Oh, he has been sitting right from the beginning. Sorry, very sorry. We didn't see you. Very well. Otherwise,
I didn't know. Lord, otherwise, I would have given way, my lord. I would have
us first. Nobody told us.
I would have given way. I didn't know.
I was asking, I asked my friend to go first. Just as a courtesy.
Lord, can I just take one more minute, my lord?
You just now said 30 seconds. And now you make it double.
17/10/2017, there is a notification under 23, under section 18. 17/10/2017. It's part of my additional documents.
Very well. What does that
It
say?
amends, my lord, the rules of 2017. There is an explanatory memorandum to this. My lord, lordships could always look into the memorandum for the purpose of sustenance, though it doesn't govern it.
Very well.
Last line, my lord, in the memorandum says, in providing retrospective effect, interests of no person shall be adversely affected.
Very well.
Please bear that in mind also, my lord, is my respectful.
see, it was interest adversely affected. You want to take a qualification, take it. Prospectively, you can always.
No, Lord, in the tea.
Mr. Jha, we'll call upon you after Mr. Khurshid.
My lord, my lord. I wait my
I'm grateful. I'm grateful.
wait my turn, man.
Well, it's grateful. Well,
You appear for whom?
two very short points, Mullahs. I mean, item.
No, not the item. You have to
All
make
right.
the
First
party.
for Meghalaya Sarv Shiksha Abhiyan School.
Meghalaya. मैडम इसमें से मेघालय ढूंढिए ना मैडम कौर नहीं इसमें अलग ऊपर नीचे हो गया है मेघालय व्हाट इज
It's called Meghalaya Sarv Shiksha Abhiyan School.
सर्व शिक्षा
Sarv Shiksha Abhiyan Schools Association.
देखिए तो स्टेट यस स्टेट मेघालय
Mr. Advocate General is here, Mullahs.
सर्व शिक्षा अभियान स्कूल्स एसोसिएशन So, sir, your points raised in the review petition are these.
Please, Mullahs.
There was no TET when the petitioners were appointed in the state of Meghalaya. MHRD's notification dated 3rd August 2017 recognized that the existing in-service elementary teachers who lack the minimum professional qualification should be provided a transitional opportunity for upgradation rather than being summarily removed. Third, the judgment under review conflates both eligibility qualification with quality evaluation. These are the 3 points.
Those are the 3 points. I'm just very briefly going to touch upon 2 issues. One is your lordship's judgment itself, paragraph 169.
Paragraph 169.
Your lordship will just allow me to read paragraph 169. It begins at 168 and then 169. Last 3 lines of 168.
This one. And
Yes.
Well, it begins with only those appointed prior to 3rd September 2001 in accordance with applicable recruitment rules or those covered by specific exemptions such as special BTC or DED courses, etc., were exempted. So there was an exemption. Your lordships have recognized that exemption. People appointed prior to 3rd September 2001. Thereafter, my lords, your lordships then say, thus read holistically, Section 23 of the RTE Act and the NCTE notifications together establish that TET as a compulsory qualifying criteria for all teachers appointed on or after 23rd of August 2010, and as a time-bound compliance obligation for those appointed earlier without the requisite qualifications. My only submission is requisite qualifications does not include TET, but if your lordships have written this judgment, your lordship knows better what exactly it means. But that's my submission, my lords, the way I read it, is that it does not mean TET, it means any other qualifications that they don't have, they've been given a compliance period.
Very good. Thank you.
Then, my lords, just through 3 more lines. The sole object is to ensure uniform teaching standards across institutions, etc. We bow to that. My lords, your lordships have made this point about how does a notification bypass a statute. My lords, but there are 2 statutes involved here. One that I believe has not been taken.
NCTE Act.
My lords, the RTE Act. My lords,
RTE Act and the NCTE Act.
12A. And
12A is NCTE Act. 12 capital A is of NCTE.
12A capital is NCT Act. Mullahs, I just want to read out the proviso there. If your lordships will see 12A. Mullahs, the proviso only says, provided that nothing in this section shall adversely affect the continuation of any person recruited in a pre-primary, primary, upper primary, secondary or intermediate schools or colleges under any rule, regulation, or order made by the central government, a state government, Educational Amendment Act 2011, etc., solely on the ground of non-fulfillment of such qualifications as may be specified by the council. So 12A,
Next proviso.
well, I'll read the next. Provided further that minimum qualifications of a teacher referred to in the first proviso shall be acquired within a period specified in this act or under right to children to free and compulsory education act. Well, if your lordship read that with my interpretation of paragraph 169, it is qualifications that have to be complied with in that period, but RTE is not part of those qualifications. That's my submission, my lord. I'm
Thank you very much.
grateful, my lords.
Yes, Mr. Jha, who do you appear for?
My lord, I appear for the Tribal Welfare Association of
just
Teachers. I'm grateful, your lordships permitting me to appear through the
Yes,
VC.
yes, please. You are appearing for which state or?
I'm in item number 301.68 for the Tribal Welfare Teacher Association of Madhya Pradesh.
Tribal Welfare Teacher.
Teachers Association of Madhya Pradesh.
एक बार देखिए ना इसमें कहाँ है? Tribal Welfare
Teachers Association.
मध्य प्रदेश के आसपास ही होगा.
Yes, ma'am.
अच्छा, point, sir.
My lord, your lordships, I wanted to assist your lordships in interpreting the proviso.
Yes.
Both of them. And since your lordships have positive time, just read it, my lord. Provided that the teacher who at the commencement of this act does not possess the minimum qualifications as laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years. And the second proviso says that as on 31st March 15, who are there, if they don't possess it, they will acquire it within 4 years. Now, the section statutory provision says qualifications as laid down under subsection 1. Now, the qualifications that have been laid down under subsection 1 are under the notification of 23rd of August 2010, which your lordships have reproduced, considered on several occasions. But there are certain aspects of it which I want your lordships to just see along with me, my lords. Here, my lords, if your lordships will see this notification, there are 4 categories of teachers here, not a single category.
Yes.
The first paragraph, my lord, deals with the qualifications that are prescribed for fresh recruitments after the coming into force of the act. And if your lordships will see under the first paragraph, and TET, which your lordships are concerned, and TET, along with certain qualifications that are mentioned, senior secondary with certain 50%, etc. And in both cases, A and B, it's and TET.
Yes, pass in the teacher eligibility.
Yes, ma'am. Then if your lordships will turn to paragraph 3 of this notification.
Paragraph
it
3.
says- Paragraph 3.
Yes.
Training
to be under.
Yes, madam.
Training to be undergone.
Yes, madam. It says with BA, BSc. Now, this is something apart from what has been mentioned in paragraph 1. BA, BSc with 50%, B.Ed qualification also eligible for appointment to class 1 to 5 up to January 2012, provided he undergoes NCT recognized 6 months special program elementary education. So even those who don't possess the qualification prescribed in 1 but are BA, BSc with 50%, if they undertake 6 months training, they are qualified. Same is with D.Ed, that is in B. Then 4 comes another set of teachers. They say the following category of teachers appointed in class 1 to 8 prior to the date of notification need not acquire qualifications specified in 1. And here 3 instances are given. Teachers who are appointed.
Sir, your contention overlooks the minimum qualifications which are prescribed under paragraph number 1. Paragraph number 1 deal with minimum qualifications.
My lord.
Minimum. These may be additional qualifications that are required. Diploma, degree course in teacher education. But the minimum is you must have for classes 1 to 5, secondary or senior secondary or senior secondary. Either of these 3 plus TET.
Plus
this is for classes 1 to 5. For 6 to 8, you require BA, BSc or again BA, BSc or BA, BSc, senior secondary or BA, BSc. These alternatives are there, but passing TET is the mandatory qualification.
My lords, why respectful submission before your lordships?
You cannot say that if somebody has the qualification in 2, he may not have the qualification in 1.
The reason is, my lord, that the competent authority, that is NCT itself, saying that if these people possess this training, B.Ed, which it has prescribed previously, if they undergo 6 months special training, that is a BTC training which is prescribed there, they will be deemed to possess the qualification prescribed under subsection 23(1). And for these teachers, these 4 categories mentioned in paragraph 1, 3, 4, and there's a 5th category which says that those teachers whose recruitment started prior to the coming into force of the Act and were recruited under the regulations of 2001, they also will not be required to have the qualifications mentioned in para 1. So my respectful submission before your lordships is that the proviso says qualifications laid down in subsection 1. And the qualifications that have been laid down in subsection 1 for us who were working for a very long time is covered either under para 4, 5 or para 3.
Very well.
Para 1.
We have noted.
There's another very big difficulty in Madhya Pradesh. In Madhya Pradesh, the recruitment rules that were existing at the time when we were appointed did not require 50% in higher secondary for appointment. It was simply higher secondary pass. Now at this stage, if your lordships relegate us to TET, we will not even be eligible to participate in TET because we don't have 90% of the teachers of this association who are working in tribal areas don't even have 50% at that time because they were appointed 20 years ago.
Our order only says that you need to qualify in the TET. At this age, you will not be required to go back to the high secondary level and cross 50%. That is not the purport of our order. Our purport of our order is, if you are a teacher in position, if you have not acquired TET by now, you do it by 1st of September 2027.
No,
we are not required to go into this 50% higher secondary pass qualification at this stage.
But these authorities, my lord, here in Madhya Pradesh, when they are drawing up the list of people who to go through this, they are looking at this 50% qualification and saying you are not qualified.
If they look at it and if you are, if it is applied against you, you may seek your remedies before the appropriate forum. Thank you very much, Mr. Jha. Thank you very much.
There was a-
My lord, one
Yes,
submission.
my lord,
one
and
for
yet
Meghalaya,
another-
state of Meghalaya.
There's
Only
yet
one
another
submission,
issue here.
alternative submission.
Just 1 minute. Yes, yes.
There's one issue, one extraction. I beg your lordship's indulgence.
Yes, yes.
My lords, in the state of Madhya Pradesh, there are certain scheduled tribes, and they are Baigas and others. And when teachers were appointed there, the state government has enacted an act, statutory provisions for tribal welfare. Under that act, these teachers were given exemption from acquiring necessary qualifications for appointment. Now, I have given list of teachers who were appointed as teachers and are working there in these tribal areas. They are tribals for the last 20-25 years who do not have this qualification, and they are going to go out simply because now your lordship say that TET has become, though TET is not there in the statutory provision of the act itself, it's prescribed by the notification. So, my lords, my submission is that these people would go out straight away. And this tribal area where no teacher is willing to go, where schools are not even available, infrastructure is also not there. And these teachers have been, for the last 20-25 years at least,
Sir,
producing.
if there are qualified teachers who cannot be appointed because of dearth of vacancies, definitely they will be going.
Nobody is,
Notwithstanding that the
nobody is
vacancies
willing
in a
to
tribal
go and
area.
nobody is willing to go and work in tribal areas.
No, no.
That's why, my lords, the non-formal education and other programs.
If this submission is accepted, then after 2010, anyway, no teacher can be appointed for a tribal area.
My lords, this is the factual situation in
This
Madhya
is all an emotional argument contrary to law. This cannot be accepted. Then after 2010, no recruitment is taking place for tribal areas. Is your
I just
submission?
point out. If your lordship will give me a minute, I have filed documents to.
It doesn't sound tenable at all.
No, my lords, it's not my submission. This is the government's own stand. I filed documents to indicate.
Very well.
The
Thank
government.
you, thank you very much.
We have understood.
Thank you very much. Yes,
I
Meghalaya.
have one alternative submission, my lord.
Yes.
We have total 38,256 in-service candidates.
How much?
38,526.
38,500?
38,256, my lord.
256.
Out of which we have
You're representing the
state of Meghalaya.
State of Meghalaya.
Yes, my lord.
Yes.
And out of which we have 5,912 MTAT qualified teachers, my lord.
5,912
5,912
TET qualified.
TET qualified teachers.
Right.
We are holding the examination, my lord, on a regular basis. We would be requesting that some sufficient time may be given so that we can comply with the order. I have
So our order is, the
Only
deadline
for
is
1st September.
31st August 2027.
Yes, my lord, 2 years, my lord. We have
2 years.
The
In
issue
2
is
years'
that
time, you conduct two
we
examinations.
have been conducting the examination, but we have got Garos and Khasis region, my lord. Yes, we are holding the examination.
Four exams.
But
you get.
the issue is, my lord, that Garos and Khasis are tribes and we have got the local languages. To filling up those vacancies, my lord, in 2 years may be difficult. We are asking for some more time so that we can comply, my lord.
Well,
I understand
please
the
17 till now, 20.
yes, I understand, my
9
lord, that judgment came on 1st September 2000.
But this was the statutory provision.
Yes, my lord, that I have
We are
seen
only
and I have,
implementing the statutory provision.
yes, my lord. The only difficulty is that if the
Well,
this is
we'll
implemented, we have
between Mr. Rahim and Madam Mona, who is senior. Yes.
I only look old, ma'am.
Huh?
I only look old.
You look old.
Oh, she looks younger.
Thank you. Lord,
You are for whom, madam?
Lord, I am appearing for all postgraduate teachers welfare association item number, my lords.
All postgraduate teachers welfare association.
Item number 30154. 301.54. Teachers of West Bengal, my lords.
West Bengal?
Yes, my lord.
1 minute.
Postgraduate on honors, my lord. These teachers are all, actually they were recruited for up to higher secondary. Not in West Bengal, your lordship may probably know that there is a category called normal teachers, and there are separate teachers for primary, upper primary.
What normal teachers?
Normal teachers has meant
I have not heard about normal.
there are notifications by the government also.
What normal teachers, Mr. Rahim? Have you ever heard?
There are notifications. Normal
teachers, no.
sections.
What is the other category?
Normal sections are.
What
They
is
are,
the other category?
they are called primary and higher secondary. These normal.
No. We have not heard about normal.
Very well, not. These are categories. We were all educated for post-graduation also, for teaching post-graduation also. Our problem is, one problem is a peculiar thing that I will come in the end note. Here, when I am reading section 23, your lordship's first question was, will you please satisfy what is the second proviso up to? I will try, my lord, to satisfy that this will not be applicable.
Please.
Lord, I will read the section again. Any person possessing such minimum qualifications as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. So any person who fulfills will be appointed as a teacher. Whereas state does not have adequate institutions offering courses or training in teacher education, or teachers possessing minimum qualifications as laid down in one are not available in sufficient numbers, the central government may, if it deems necessary, by notification, relax the minimum qualifications required for appointment as a teacher for such period not exceeding 5 years as may be specified in that notification. In this, my lord, stopping here for a moment, there are 3 stages at which, my lord, they can extend. One, my lord, when the notification newly coming and the act is new, my lord, then there is no provision by the state giving you more institutions. There are no colleges offering this education. There are no courses or training for this teacher education. Therefore, my lord, this 5-year period from the date of the enactment came in. Now, when within the 5 years also, my lord, provided that a teacher who at the commencement of this act does not possess minimum qualification laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years. This is what was read in that notification, a subsequent letter which government clarified that this is not applicable to the in-service candidates, which was read out before your lordships. Your lordship's query is provided further that every teacher appointed or in possession as on 31st March 15 who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualifications within a period of 4 years from the date of commencement. Lord, this has been given only with a view to this 15 is a 5-year period which they fixed from 10 to 15. The act came in 2010. It gave, the first proviso gave 5 years time to fulfill the qualification. So therefore, my lord, within the 5 years, since there were not many institutions offering this course or not unable to complete the qualification which is prescribed by this enactment, your lordships are seeing even today, states are coming up and saying we are unable to make up this institution, making them get educated for TET. So the likewise, my lord, it's a new enactment, and since even the new teachers who are recruited and in place in 2015 unable to acquire TUT, therefore, my lord, this proviso 2 was introduced in my humble submission. It is not that a proviso which was actually a benefit which has been granted to in-service candidates could have been again revived by the second proviso. It could not have been revived, my lord. Number 1. And then, my lord, I am only reading the one again, is that a person possessing such minimum qualification as laid down will be eligible for appointment is there. It doesn't say shall be eligible to continue as a teacher. If at all the enactment wanted me to go out when I don't have the TET or the qualification which is prescribed in this section, the section 1 should read like this: shall be eligible for appointment or to continue as a teacher. Since there is no such, my lord, prescription in this enactment, this honorable court, my lord, in my humble submission, could not, my lord, presume a retrospective application of this act. Your lordships are aware, my lord, I can't carry coal to Newcastle. Devin Cutty principle, which is till date may not pursued, followed by this honorable court, is that when an advertisement is issued, when somebody is recruited, you have to only go by the rules then in existence. You can't subsequently, after a person joins a service, you cannot now retrospectively apply a rule which is now introduced. And then, my lord, for the basic service law principle, my lord, this will be, if this interpretation, if it is given, that even to continue as a teacher, this provision will be applicable, will be contrary to the basic principles, in my humble submission. Your lordship will also...
Thank you, madam.
Lord, just one more, my lord.
Thank
Lord, the normal section is what the West Bengal says, is that, my lord, our appointment itself is for the High Court judgment also in several cases mentioned that is a normal section will include from 5 to 10, my lord, class 5 to 10. The peculiar problem for West Bengal teachers today is that, my lord, we were teaching up to 10th. In fact, we can teach higher secondary also. But due to this bifurcation, my lord, now they are made to teach only upper primary, asking me to now get a TET qualification, which is peculiar to West Bengal, my lord. I am a postgraduate with the training to coach, my lord, even the higher secondary. So therefore, we have a problem.
Thank you, madam. Yes,
Very
Mr.
well.
Raim. Who else is there senior to you?
Who is of course also retired.
I'm simply
Acha, Mr. Gande is there.
301.62.
Acha.
My lord,
You are appearing for?
301.62 intervention applications on behalf of the teachers. Lot of arguments have been argued, my lord. Only this, your lordship has also said, pointed out in the para
Acha, this is this serial number?
301.62 intervention application
Intervention application in 301.62.
on behalf of
Yes,
teachers,
yes, please.
700 teachers. my
Yes,
lord.
please.
Prior to 2001, they were appointed. And in para 62, your lordship has already quoted and that has been argued. 4, and there is an exemption of TET. My submission is this, that we are exempted in accordance with that. TET is not required. Second point is this, that Article 309(11)(2), it is a status and it cannot be taken away. The main argument is, as I was hearing, that looking to the teachers' efficiency, this examination is necessary. It is a dangerous trend. It can be in every service. That is the main point.
21A has been brought in with a purpose, sir.
So, my lord, then to every service.
Very well. Yes, Mr. D.S. Naidu now.
May it please, Millets. Millets, I represent the teachers from the state of West Bengal. And they were all... Please.
Mr. Rahim, Mr. Bhattacharya, Madam Mona, you also.
Yes.
Only 1 minute.
Lord, it just shows, my lord, that the teachers over there. It just shows, my lord, that the apathy of the teachers over there, how they're affected.
Because, my lord, the state of West Bengal and board has not come out.
Nice.
Millets.
Well, just 1 minute. Let Mr. Naidu come. Today we will not.
If I'm permitted 30 seconds, Millets.
Yes.
If I'm permitted.
1 minute.
No, Millets.
1 minute. No. Because we are hearing the same argument again and again.
Yes.
We have been indulgent, but that does not mean Mr. Naidu.
Absolutely, Millets.
Right,
I can
that
never
same
overcome your
argument
lordship's
will be,
kindness. Could my lords
presented
have-
for us in a different language.
Compilation.
Just 1 minute. This is a review. We have heard from 2 o'clock, right?
We're all great.
The review, the error has to be such that it does not require more than a minute's argument to demonstrate.
Precisely. Millets. Could my lords have, since I've taken the SCC copy of your lordship judgment.
No, we have the SCC copy.
Yes, Millets. Could my lords come to para 90?
90.
90.
That is the
That
bedrock of the
permeates.
judgment.
That permeates.
Para 90 is the bedrock of the judgment.
Indeed, Millets. That's why I begin with that one. That permeates the spirit of the judgment. And my lords have taken recourse to, in my humble submission, a purposive interpretation coupled with Hayden's principle of curing a mischief. This is one thing. And Millets, the question that I may have to pose myself is this, Millets. Can a qualification which has not been explicit be read into any recruitment?
2017, this proviso was brought in.
Yes, Millets.
Right. Why did you not challenge it?
Obviously, Millets.
Why
my
did the
humble
teachers not
submission is-
challenge it?
My humble.
Just tell us this.
Yes.
It has been almost 9 years on the statute book. The parliament wanted to give 4 years time, but it is brought into effect with retrospective effect from 15, thereby curtailing that 4 by 2 years. And even then, West Bengal teachers, they did not rise from their slumber.
My answer is this, Millets.
Now everybody.
We have never.
Now everybody. What now everybody? What is the...
Millets.
If we interpret the law as you are asking us to interpret, this second proviso will be rendered redundant.
May I say with great respect, Millets, the only difference between first proviso and second proviso, as I understood, was that, Millets, whatever the time frame that was given, there were representations from various states, and it was extended. So the first proviso, if good enough, the second proviso is only otious, except to certain categories of extension of time.
Proviso makes it absolutely clear.
It's been made explicit, Millets. It's been
Whatever
made explicit what is
ambiguity was
implied.
there in first proviso,
yes, Millets,
that ambiguity is removed by the second proviso.
Millets, that's what I say, Millets. It's only clarificatory in nature rather than giving anything extra, barring the time frame that's been extended. My humble submission is this, Millets, that has been repeated, that the section does not, or rather the article and the section, they do not read anything vis-a-vis the qualification or minimum qualification. I was recruited, we were all recruited for that matter, between 2001 and 2010. Then millards 2010 rules superseded. Then 2011 there was an amendment. Eventually 2014 was the culminating factor. Millards, amendment or no amendment, my submission is this, millards. All through I've been qualified when I was recruited. And millards, I've had a vested right in the process of my recruitment and my appointment. And millards, any rule or regulation which has come in effect, if that supersedes something else, millards, the vested right in terms of Section 6 of Gender Clauses Act cannot be diluted. This is my humble submission.
Very good.
Lord, only,
Yes.
Lord,
Yes.
I will not repeat anything, my Lord. I will not repeat anything. Lord, your Lordship may kindly see, my Lord, your Lordship, my Lord, at the heart of the judgment, my Lord, is the fact that your Lordship mounted, my Lord, uniform teaching qualifications, A, and your Lordship said, my Lord, that TET is a constitutional necessity. For which reason, my Lord, Article 21A, and my Lord, the provisor, my Lord, your Lordships have, my Lord, held it very firmly, my Lord, and rightly so, my Lord. Now, my Lord, today, my Lord, the ground reality is this, my Lord. In Bengal, my Lord, the first TET was held in 2014. No, the exam
Everything
was,
will change now.
no, I'm not
Hopefully.
saying, I'm saying,
Hopefully.
we all pray for that. We all pray for a better.
Let us hope for the
Yes,
change.
of course, we would.
There is an order.
Yes, sir.
There is an order of this court. 2027 is the deadline.
So, my Lord, if your Lordship, my Lord, say the second was held, why these people did not come, my Lord? The second was held after 7 years, 2021, A part. B is, my Lord, if your Lordship sees, my Lord, your Lordship.
Everyone was looting the state.
Lord, that, my Lord, is that teachers,
So
my Lord,
now let us hope for a better future.
we always have to, my Lord, look to a future, to a dawn, my Lord. We
Lords, I
can't-
can appreciate
only 2-3
this
things.
happened almost 20 years ago. By then it was not in
Only
contemplation.
2-3 things.
Neither the
Lord,
constitutional amendment
Lord,
or the enactment, neither of them was there,
Only
millards.
2-3 things. Lord, the word which was troubling your Lordship was, my Lord, if your Lordship sees, my Lord, your Lordship has seen, 23(1), my Lord, your Lordship said, my Lord, any person, and you were not a teacher at that point of time. But if your Lordship sees, my Lord, the proviso, my Lord, the first proviso. So provided that a teacher, now the word person here, my Lord, should be read to mean a teacher. Provided that a teacher.
Sir, 23(1),
Yes, my Lord.
at the risk of repetition, we are saying 23(1) says,
Yes, my Lord.
any person who wants to be a teacher
Please.
must have the qualifications under 23(1).
Correct.
Any person who wants to be a teacher. And first proviso says a teacher. So that presupposes that you're already in service. So if you're in service, you are given 5 years time to upgrade yourself.
To give the
Millard, there were instances, if I may add, Millard, there were instances when relaxations were made.
Like a broken record, we have been repeating the same
No,
thing
Millard.
again.
There were instances when
Would your
there were
Lordship then only
instances
indicate
when
something, Lord? I will.
states represented to the central authority
I will only
that
reiterate,
because we
Lord,
don't
what-
have the wherewithal, it should be exempted. Such
there are two-
categories which have been exempted from minimum qualification, they were given this opportunity, not the ones who had the qualification by word go.
Would it be 4 years, my Lord?
Why we didn't challenge it? There is a letter of 2017. It is a the amendment of 2017. Now,
Whose letter?
sent
This
to
is already there 6 months.
MHRD's letter, which reflects
What is the date?
3rd of August 2017. The amendment came on 10th of August 2017. Now, this letter of MHRD,
3rd of August 2017. What did it say?
I'm
Just tell us.
It laid down detailed guidelines to all states and union territories about gaining the qualification required and to meet the deadline. And the only thing it referred to and discussed in detail is getting a DLED, which is a Diploma in Elementary Education. And this, Your Lordship, the reason why this is important, I tell Your Lordships, Regulation 5, Your Lordship will again, I'm sorry to say, read Regulation 5 of NCT 2010 regulations. Regulation 5 very categorically says that those regulations...
Can you please come to para 69 of our order?
Yes, Your Lordship.
Have we read 3rd August 2017 erroneously?
I tell you, Lordship's fine.
Just tell us that.
Yes, sir.
Just look into 69. Have we read the 3rd August 17 order erroneously?
No, but the question is...
We have said, Madam, just see 69.
What were the...
Additional Secretary MHRD issued a letter to the state secretaries reminding that the last date to acquire minimum qualifications is 1st April 19, and no teacher who did not possess minimum qualifications under RT would be permitted to continue in service beyond the given date. Is it a wrong interpretation of the letter?
No,
Lordship did not interpret the letter. Your Lordship merely said minimum qualifications. But what are the minimum qualifications? The question. There are 22 steps which the 2017 letter talks about. Everything involves diploma in elementary education and online distance courses for diploma in elementary education. There is not a whisper about TET in that.
Very well.
And I'll tell you, Lordships, why that understanding is. That understanding is in consonance with Regulation 5 of 23rd of August 2010. The Lordship just read Regulation 5 1 second. I know your Lordship has read it. It very categorically says, where an appropriate government or local authority or a school has issued an advertisement to initiate the process of appointment of teachers prior to the date of this notification, such appointments may be made in accordance with NCT 2001 regulations. Under Section 23, the gold standard is NCTE. 23 does not say what your minimum standards are. 23 says NCT will lay down minimum standards. Rightly or wrongly, NCT 2010 has two categories. Those who are prior to the notification, those who are post-notification. Whether it is in one way or the other, that is a law. NCT 2010 is a law. It is in consonance both with 12A of NCT Act as well as RT. It is not contrary to either. NCT 2010 notification creates two categories. Those who are appointment prior to the notification date and post notification date. Prior to 2010 notification date, they say the standards and qualification of 2001 will apply. Post 2010 notification, 2010 will apply. So all those who are selected prior to a selection process prior to 2010 are governed by NCT 2001. It does not mean there are no standards.
Very well. Thank you.
And that
Anyone else?
They form a different class when it comes to 2000 up to 2010 minutes.
My lord,
Form a different class.
my lord, I am appearing for Women Teachers Association.
2010 may be a justification.
Should the TET exams be held after every 6 months, my lord? Otherwise,
I am appearing for UP Women
Mr.
Teachers
Rai.
Association. UP Women Association, my lord, of teachers of UP, my lord. My lord, the only one, first of all, my lord, there should be a schedule in which, my lord, the states have to conduct these exams, my lord, so that all the backlog may be cleared, my lord. That is the first, my lord. And secondly, my lord.
In case they are not holding the exam within time, you are at liberty to approach the court. The problem is,
My lord, it doesn't happen, my lord. My lord, if it is a part of the order, my lord, they will listen to it, my lord. And then, my lord, lady members, my lord.
You find you were here right from the beginning.
Yes, my lord.
What did Tamil Nadu say?
Yes, my lord. They said 4 years, my lord. Then my lordship accepted.
No, because they say that if the teachers in position, they don't qualify, we will be without
schools will be
teachers.
closed, my lord. Yes.
So whose duty it is to hold the TET under the law?
States, my lord, but they.
States?
Yes, my lord.
Now, state on the one hand will say that don't require TET to be acquired by the teachers. On the other hand, they will say that we will be out of teachers.
Yes,
What is
my lord,
this?
lakhs of vacancies are there, my lord, in the schools, my lord. They are
So
not.
there are lakhs and lakhs of individuals who have qualified TET and are waiting in the wings. Let them be examined. Let them be assessed.
Yes, my lord, I'm only praying, my lord, to give some exemptions to ladies, my lord.
Sorry?
Some exemption to ladies.
Ladies are in our judicial service more than 50%. And you want exemption for ladies?
My lord, now the situation is different.
Just see the judgment authored by Brother MANMOHAN in Arshnur Kaur.
You have said now their time has come and there will be reservation for men.
My lord is absolutely right, my lord, but reservation is now happening in Supreme Court also, my lord.
My lord, may I, my lord, only take 1 minute, my lord? My lord, only one.
Please allow us to reflect.
My lord, may I hand
What
over
is
just
reserved
one
for the-
notification?
My lord, only 1 point, my lord.
We will have to work it
My
out.
lord, 30
Whatever
seconds,
is
my lord.
best for the-
My lord,
May I hand
30
over just
seconds,
one
my lord.
notification?
Only 1
Let's
point,
make
my
a
lord.
limit. My lord, may I hand it over just two notifications? Nothing more, nothing less.
Very well. Give the notification.
May I hand it over this?
We'll
My lord,
consider.
one is state
Yes,
conduct guideline and another one is
For the
extension.
Golden Forest matter.
My lord, only one line.
Your Lordship, just to
One
thing, my lords, I wish
My lord, can you consider
Your
the
Lordship, I wish to
extension?
point
West
out
Bengal
about
extension.
Jammu and
Nothing more,
Kashmir.
nothing less.
May I make a limited submission?
301
Only on the retrospective effect.
We will look into
Your
all the
Lordship.
positions, whatever points are there. Our notes are ready. We will
Your
look
Lordship,
Correct.
Your Lordship, may I?
Lordship, very
Your
important
Lordship, may I
2
just
points,
submit
which
one
is
thing?
already concluded in the entire matters, Lordship.
Your
First
Lordship,
is there,
Golden
give the
Forest.
Lordship the time to the teacher eligibility test for, and second is there, Lordship, very important.
We will
the
consider.
attempt,
Your
Lordship.
Lordship,
Give the attempt to the more
Your
than
Lordship,
one to
may I
more
just
than.
submit about
Third is
Jammu
that
and
Lordship,
Kashmir?
very important. Physical education and the music teachers is not considered under the act of the TET examination. In this, Lordship,
Sharma ji, bulaiye bhai.
Your
please, my lord, only
Lordship.
one sentence, my lord. My lord, they are, my
Your
lord,
Lordship,
the
may I just
teachers are
submit
ready
about-
to
We are appointees prior to 2009. We are ready to give the TET test. Only we should be given promotional post also. And if we fail, my lord, we will lose the service as well as promotional post. That is only what our contention is there.
I seek permission to withdraw 301.4.
Forest.
I'm for the promoter.
No, first, today we'll hear Mr. Fernandez, Madam, and Mr. Prasad.
Only last time, Lord, you all should issue notice in my application.
Wait for a minute. Get all the DC and the
Yeah,
local
they are-
I know, so
local
that,
admin video.
that report has come, Lord, where they say that they have 400 crore.
No,
200.
not that 400 crore. Whether they have taken.
Oh, I see the deputy commissioner. Lord, at some stage, your lordship will have to
Yes.
hear the surplus. Where will the surplus go? That hearing your lordship will have to.
There is a minutes of meetings that we filed yesterday. Because we were to, yeah, we have hard copies. We have hard copies. We just hand it over. Your lordships. Yes. So we've given the modalities, my lord. We are very sorry. Your lordships directed us 48 hours before. Yes. So therefore, my lords, SBI CAPS is going to be the agency which is going to conduct it.
Yes.
And they have given a detailed timeline, a detailed schedule in terms of various steps to be taken. Your lordship straight away comes to para 6, para 5 onwards. Page 3. Page 3. It's para 5. There's a common consensus, my lords. We spoke to income tax, SBI CAPS, the Hyderabad office, the GFIL committee, and the amicus. So SBI CAPS, my lords, will be at para 5, the agency tasked to conduct the auction. At para 6, my lords, auction would have 3 phases: pre-auction phase, actual auction, and number 3, post-auction modalities. If your lordship kindly comes to para 7 at page 4, we have given the various stages, the respective milestones. So on the left-hand side, phase 1 pre-auction. So in that, there are 3 steps. The first step is receipt of necessary information, because we have clarified that below. What is that necessary information? That shall be the starting point, T0. That will how the limitation starts. And everything will have to be given to SBI CAPS. After they receive at serial number 1, then at serial number 2, SBI CAPS will prepare the model tender documents and the RFRP, request for proposal, the bid documents that they will prepare, which they will take 60 days. So T plus 60. And then number 3, approval of the RFRP and the reserve price notes, that the income tax department and the Golden Forest Committee together will assist your lordships in that. So this is stage number 1. Stage number 2 is the tender approval from the department. So once
just 1 minute, Mr. Fernandez.
I'm so sorry.
Report of the committee, this exercise will have to go later. I'll tell you, lordship, why. The report of the committee says it has got 404 crore with it. Verified claims is only 200 crore. Rest are all unverified claims. Let them. So unverified means where checks have gone and returned, or checks have.
If there's surplus with the company, it will remain with the company.
No. So that's what I'm saying.
No,
but why should it be this piece put to sale if the money already with the company is more than not sufficient to be?
If the company is to be liquidated and it has gone to liquidation.
It's not to be liquidated. I'll tell you, lordship. So this is a matter where just give me 5 minutes, 2 minutes, lord. This matter is a matter where at all points of time, right from 98 onwards, 2006 on affidavit, lord, it has been always disclosed that the assets of the company have always been more than the deposits taken from. No case of diversion, no case of money laundering. It's only a question of Lord SEBI saying that you had not registered with us, and because of which Lord SEBI imposed a restriction. 86 to 98, company has been servicing every Lord depositor without any default. Today there is no there is no issue Lord with regard to any default.
That cannot be. This company has been lying before us for how many years?
No, I'm talking prior to 20 years. I'm talking of 98, which is 30 years.
Just wait. We'll have to go through this.
No, I'm just giving, because if your lordships get into this exercise, if there is enough money already with the committee, Lord, has already worked for about 20 years.
Who are you appearing for?
I'm for the original promoter, Lord. I hold 72% of the shares. I've been there, I've been appearing in this, I've been appearing, no, what will happen? Today, Lord, today the property value is, Lord, 4,800 crores.
Submission that I'm contesting
No,
is.
no, but there has been no, there is a 2006 order. There is a 2006 order. Can I just, so she can't just start in between, I'm still continuing, Lord. There is a 2006 order where your lordships have taken a view that how will the surplus be dealt with has to be decided by this court. That has never been decided by this court.
Decide once there is.
No, but why should there be more money if there is already enough money lying in the committee?
Company is dead today. Who's functioning?
No,
Company is
company
not
is,
functioning. For last 20 years it is
the
not
company, there is no liquidation order. Please appreciate.
There has to be.
No, there is no liquidation order. Your lordships have transferred everything here.
Yes, it will stand liquidated. Only
Principal interest. Even if it is, let me assume, even if it is liquidated, ultimately.
We'll give it to the shareholders.
So I'm holding 72%.
You'll get the money in case
So
you're
I'm-
entitled to it.
They will definitely.
I'm only saying,
Every
Lord,
shareholder will get it.
your lordships are not doing a liquidation proceedings.
We
Please
have to do
appreciate.
it. 20 years
Yes.
the company has not been functional. See, company is
Because of SEBI. 98 SEBI interdicted the company from doing anything further.
Maybe.
And there is a restraint order operating.
Whatever it may be, the company is non-functional for last 20 years. It has to
Because
be
of
functional.
SEBI, Lord, because of SEBI.
Whatever it may be, Mr. Singh, it will have to be struck off the rolls.
It
The
has
company
not,
not
Lord,
functioned
please
for 20
appreciate.
years.
It is
We'll have to
all,
take it to
it is
liquidation.
all under Lord interim orders.
No, Mr.
That this is all
Anyway, Mr.
continuing.
Singh, this argument does not appeal to us.
Your lordships are not doing liquidation. Your lordships are only dealing with, Lord, the claimants.
Just
And
wait.
your lordships have been actually extending. The last date that your lordship extended was, Lord, July of 2025. Now, July of 2025, all the claims that have come, they say is only, Lord, going to maximum. Unverified claims also will take it to another 160 crore as against what money they already have. 160 crore is all that is required. So why should the company go in liquidation? The liquidation order has not been passed till date. So sometime your lordship will have to hear us as to whether what will be the status of the original promoters or the shareholders, so to say.
First of all, we'll have to decide the promoters.
I'm only saying give some hearing. Give some hearing.
No.
No, the liquidation. Just see,
Third more.
there is no liquidation order passed.
Investor forum. It was my application that 2018 this Honorable Court directed that at least 70% of the principal amount should be disbursed.
Disbursed.
Was disbursed. Now only 30% is to be disbursed so that at least principal amount
That's only principal.
is disbursed to the investors who are traceable. For 30% is status report says that only about 200.
No, see, but the problem today.
And they have 400
No,
crore.
no. See, Mr. Singh, it doesn't work like this. Suppose there are 100 shareholders. You cannot say that 30 are traceable, 30 will get their entire money.
Shareholders, depositors.
Whatever it is, out of 100 depositors.
950,000
So-
investors
so-
are traceable.
No, but how many are there? How many is the total?
No, your
You know the
lordship.
total figure?
No. So to decide,
It's not correct.
one second. Let me explain, Lord. Let me explain.
How many investors do you have?
Let me explain, Lord. This is a
Approximately
matter.
24 lakhs. Approximately 24 lakhs.
This is a matter.
out of 24 lakhs.
This is a matter which has engaged the attention of this court. In 2006, your lordships gave a cutoff date. Anybody has to apply by that cutoff date. Only is to be considered to be an investor. Thereafter, your lordships extended that date to July of 25.
Saying the act does not work in that manner.
No, but your lordships have rejected claims of people who came after the cutoff date. High Court has a rejected claim of people who came after the cutoff date. It can't be only to not ensure
No,
that the
then
committee.
go to the investor protection fund. There's a
Just
statutory
see the
provision.
affidavit of the committee. Just see the affidavit of the committee, my lord.
Statutory. Please examine it, Mr. Singh. Please
No,
examine
I'm
it.
saying just see the
There are
affidavit. of the-
Forget the committee and us. See, we are all governed by law.
No, but the
Some
committee
institution
has,
of ours
no, there is
governs the law.
there is
We are
a
all-
date by which people have to come and make a claim.
So, if the claim is not made, the money will go to the central government. Under
It
the,
can't go to the central government. Where is
it goes, there's an investor protection fund.
but there has to be some investor first for that purpose.
Sahara 75%.
There has to be an investor, and supposing there is an investor who makes a certain amount of claim, it can only be.
Just wait. First of all, where is the state? Yes, ma'am. Your officers are online.
Yes, madam.
Yeah, please ask them. Yes.
Mr. Anurag.
Good afternoon, sirs. Good afternoon, sirs. I am Anurag, District Collector, Yadadri Bhuvanagar District, sirs. Sir, as per the direction of the Honorable Court, we have complied with the direction. I have filed my report also, sir. We have erected boundary stones. We have displayed display name boards. We have kept the entire scheduled property under a prohibitory list. And in addition to that, every month we have formulated a team which will check every month whether the instructions are being complied or not, sir.
And you have issued directions to the registry not to register any sale.
Yes, sir. Yes, sir. We have issued directions, and the registration department has also kept it in the block list, sir. No registrations can happen, sir.
And you have also instructed the police.
Yes, sir. We have written to the
1st of
police
May,
for
dated
protection.
affidavit 1st of May. It includes the photographs and the fact that the action taken in para 3.
Yeah.
Para 4.
Vending का powder भी नहीं था, उसमें condition proceeding था,
एफिडेविट निकालना बेटा, हमने लिखा रहा था।
I know, I've seen that. No, 22 was this, not pictures. 22, yeah.
Okay.
Just see the committee's latest affidavit. That will make things.
We'll hear you. We'll hear you, but this, we are just pointing out, you also consider the statutory provisions.
Yes, yes. I'll show investors fund. What is it meant for?
Yes.
And whether it will apply in this case or not.
Yeah.
I'll
Suppose there are 100 depositors, if 30 come to court, we cannot say that 30 will get the entire money and 70 will get
No. So who is a depositor is to be decided. Either somebody makes a claim or there is some record of the company.
The record will indicate how many investors
So
are.
that on the basis of that record, your lordships gave
Suppose
several.
you are saying 24 lakhs, someone said 24 lakhs.
Yeah,
17 lakhs.
All that these are small amounts. So all that results in 400 crore only. That's all.
What about the interest? You're not factoring.
No, I'm saying give them interest also.
18% minimum.
For 9 lakh. The affidavit that we have received, and everyone we are telling you, the affidavit which has just been given to us by the amicus curiae states that he has to take some preliminary steps, which will take about 60 days. Right? That is collating of information. I think we'll allow them to go ahead with the first stage, that is of 60 days collecting of information. In the meantime, we'll list this matter immediately at the reopening.
For this purpose only.
Whatever you want to argue, you please argue.
No, sure, your lordship will give us some time for the, not like this, so that we should at least,
Para 9.
lordship, how the litigation has proceeded in.
Whatever you want to argue.
Before that,
I
Very good.
just one
para
submission to
9.
make.
No,
I
para
have
9. The para
one
9, there's a
one
tripartite.
submission to make.
That is the first step.
Just a minute.
Please see para 9. Please see para 9.
Just to
That is how it
facilitate
starts.
this, Milord.
So
This
first,
is
there has to be an
important.
agreement where SBI Caps is onboarded. This is at para 9. So SBI Caps has this precondition that please sign your agreement first. So at para 9, there is a tripartite agreement between Income Tax, Golden Forest Committee and SBI Caps. They three will enter into a tripartite agreement first. And once that tripartite agreement is arrived at, the relevant documents will be given to SBI Caps, which will be ground zero.
Milords, I have one more submission to make. As per the schedule given by SBI Caps and the Income Tax Department, in phase 1, there is a T0 phase, which, my lords, can be related to 11. Para 11, they are collecting all information. So all valuation. Second thing is the site plans and demarcation reports. Since the district collector is here, my lords may clarify when this can be given. It's not necessary to really give it after the tripartite. It can be taken over by the Income Tax Department from the district collector. They can take it over. So para 11, at least this information should be made available.
May I just make one dictate? Now, district collector is here. We have filed an affidavit, last order records that DBS Laboratories, Lordship has said it will consider later date. Now, no, what I'm saying is, they've said the physical inspection has been done. On affidavit, I have said nobody has come. Now, I've got photographs, I have not produced it, I can produce it. There's not a single boundary wall they've erected inside my, they say on the map it is encroached, not a single boundary wall is erected. So I on affidavit stated that nobody has come. It's a huge pharmaceutical company. Nobody has come, but in the map they say it is, I don't know how they have got it. District collector is there, so Lordship may. Because
Thank you, stars that no post has been installed on your land.
Maybe this will give them idea, but as of now, nothing has been done inside.
Lord,
So
my
at
fresh
least-
IA notices can go so that your lordship can hear.
So we'll say, yeah, in short, what do you want to say? Today, the order that we versus the last order, the district collector has joined us. He has assured us that that steps have been put in place to safeguard
This property.
the properties
Please.
of GF. The amicus curiae has handed over this supplementary affidavit. We'll quote this affidavit from para 7 to 11. We direct the income tax department to take steps in accordance with para 7, 9 and 11. Right? And we'll list this matter sometime in June.
And also the district collector to hand over the demarcation reports, not the income tax department.
The income tax department and the.
They must hand over.
District collector will
To
cooperate.
hand over to the IT department.
And on that day, your lordship will consider what will happen to the surplus. That your lordship will have to consider. No, but that will have to be considered, Lord. Your lordship will have to give a date.
Para 11.
If the cases go on my IEM, Lord, then we can have it on that day for the.
We are ready to give guarantees.
Lordship's an urgent mentioning.
Please wait.
The promoters could be heard in the interim on any date. We may have a better proposal.
Battle it out between him and you.
That we
and who is there? And
They should file a civil
If
suit.
we are out, then they will be
alive.
better
He's
position.
the
That is why probably they also want.
holder. He doesn't have a single share in his name in the register.
Just saying, pursuant to the last order, the district collector. Just take his.
Mr. Anurag Jayanti,
Sir.
District Collector,
Yadadgiri
Bhuvanagiri.
Yes, sir. Yes, sir. Present, sir.
Page 2.
Has joined the proceedings virtually. He assures us what? That steps have been put in place to protect the immovable properties of GFIs
In that district.
in his district.
There are 6 in that district, 1 in the another district.
Everything will be immovable properties. Mr. Amicus Query has handed over joint minutes of meeting dated
11th May 2026.
In compliance of the order dated 22nd April 2026. The relevant portion of this said minutes of meeting read as under. Both paragraphs 7, 8, 9, 10 and 11. The income tax department as well as the income tax department is directed to take steps to implement the minutes, implement the aforesaid minutes of meeting, in particular paragraphs 7, 9 and 11.
11-1.
11. First, the district collector shall cooperate with the income tax department and the is that SBI caps
SBI caps, yes.
and SBI caps in collation of information as well as site plans and other relevant.
And to hand over to the income tax department.
To hand over to the income tax. Not 11. Sorry, anything else? Sorry.
Because on this report, there's a small query that the success fee. Sorry.
11.2 says demarcation report. All I'm saying is I'm right there. So please let the collector hear me also, because I'm not a.
Not to be heard, but when the application report when the demarcation takes place, he's bound to take into account all objections that
Local.
will rise.
Local.
So the district otherwise he cannot will do this. He'll do this now when demarcation takes place. He can't pass an order behind anyone's back. Let us see. If there is a grievance, we are here, no? Nothing is going to happen. For the next
I just want to place it now. Next week I can remind you.
It will come in July.
Yes.
Any fixed date in July, my lord?
You'll find it in the ROP. You'll find it in the ROP.
I don't know, last day.
Thank you very much.
Lords, in one application, my lords, in one application, there has been an error.
Lordship's mentioning.
Arup,